You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University. You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University. You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All we have cause to plead. Draw near. Give attention. You shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket this morning is Martin versus the state of Florida.
Thank you, Your Honor. May it please the court, I'm Nata Kerry.
You need to speak up a little bit if you would.
Okay, how's this? I'm Nata Kerry and I represent Mr. Martin, the appellant in this case. Martin was convicted of first-degree murder of J.C. McWilliams in March of 2008. He was, after a jury recommendation of 9-3 of death, he was sentenced to death. We raised 6 issues in the brief. I intend to focus my argument today on the first issue, parts 1 and 2, involving the interrogation of Mr. Martin. We've raised 2 issues there. The first issue involves a violation of his right to silence. During the interrogation, after about an hour of being interrogated, during which Mr. Martin gave exculpatory statements, he told the detectives, I have nothing really to talk about.
Well, can we go back there? Was he at the beginning of the interrogation, was he administered his Miranda warnings?
He was given his Miranda warnings.
And did he then waive them at that point unequivocally?
He signed the
But
warnings.
you're not challenging his initial waiver of his rights?
No, Your Honor, because I believe if you talk, that's a waiver. He signed the rights and he responded to questions.
So don't we have, I was looking at Cuervo, a distinction in the initial waiver when it may be equivocal and needs some clarification versus when you're now talking, that you say something in response to a question an hour in, and this was in response to a question, that it is if Davis and Owen, don't those all deal with the fact that subsequently that you have to be clear that you no longer wish to respond to questioning?
That's correct, Your Honor.
Okay,
At this point in time,
okay.
the assertion must be clear and unequivocal.
So what was, the question was asked at that point, what was the question to Mr. Martin and what was his response?
Okay, there was no question. There was a broad exhortation for him to get it off his chest, to confess. There was no specific question here, and that's what makes this case distinguishable from
Well, do
Owen.
we have to look at it in context, or do we just look at one preceding question? Do we look at a line of questions and responses, or do we just look at one line immediately responding with someone saying, I don't want to talk about that, or I've said all I'm going to say about that?
Well, the about that, has its own particular meaning. And in some cases, the court has said the about that clearly refers to a specific question. Like in Owen, where did you put the bicycle? I don't want to talk about that. But that's not what we have in this case. In this case...
It seems as though, and you put forth your argument to refute this,
Yes.
It seems as though they're going through a questioning period, inquiring about the location of a young woman as to any knowledge or where is she, that kind of questioning. Is that a fair statement up to this point, that this is what they were doing initially?
Yes, they're asking him about his whereabouts that night.
Right, and then they started asking to the extent of where she could be found, and they kept going over the same kind of questioning, not necessarily accusing him of the crime or of a murder, but trying to locate the person, and then the response was, I don't know any more about that. I don't want to talk about that anymore. So would you start there? If I'm looking at it thinking that, tell me where your response is, why that's wrong thinking under the cases that are out there.
I'm not sure if I understand your
Well, I
question.
will make sure that you do. As I'm going through reading the colloquy that's going on here, this ongoing questioning, they're trying to locate a young woman. And there are questions and some responses to it. But they get to a point that he said, I've told you all I can. I don't want to talk about that anymore. And is that a fair characterization of where they were?
Yes.
Okay, then I would, to my mind, reading the case law, it would seem that that's equivocal. So I would like to hear your rebuttal response to that no, that's not equivocal, that's a clear, and the cases that you would rely on to say that.
Well, he didn't say, I don't want to talk about that. He said, I have nothing to talk about. And this is after he told them he'd already told his story. And now he's saying, I have nothing really to talk about. And it's not in response to a specific question. It's in response to confess, get it off your chest, you'll feel better. He says, I have nothing really to talk about. Now, he's been told you can decide at any time to exercise your rights and not answer any questions. And I don't know what could be clearer than to say,
Well, how about
I have
saying,
nothing to say.
I don't want to answer any more questions.
That would also be clear.
But saying, I have nothing more to tell you, you're putting me under a lot of pressure, which is what he said.
Right.
And I have nothing more I can tell you about the location of the body. Now,
Well, he didn't say that, though, Your Honor.
well, but it's,
They
again,
said confess, get it off your chest, cooperate. And he said, I have nothing, really nothing more to talk
and then
about.
what happened in sequence? Now you had, he said that, they went on, how much longer did he continue to talk?
The detective,
and did he confess?
well, the detective immediately argued with that statement and said, well, but your body says something different. The detective argued with it, and he says, yeah, that's because I'm under a lot of pressure. And then I think maybe 3 or more pages of exhorting him to tell the truth, to confess, to tell him where the body was. He said, hey, I already gave you my answer. Now, this is a 21-year-old, uneducated kid who's never faced an interrogation before.
Then how long after that did he confess?
I think this was about an hour into it, and he confessed. I think the entire interrogation was about 3.5 hours long.
So it was at the end of it was another 2 hours of questioning?
Yes.
And did he answer other things during that time?
He continued to say he knew nothing about it, a total of 42 times.
Well, but someone saying, I can't help you out because I don't know, I'm innocent, is what
That's-
happens in, I mean, if they said, I'm going to confess to you immediately, we wouldn't have any of these cases, right? So that's not really that unusual, that the whole idea is that somebody starts out saying, I didn't do it, and then by the end they go, well, I did do it. And what we have to decide is what happened between I didn't do it and I did do it is a violation of either Miranda or involuntary confessions, which is your other point. That this
Right.
became
Well,
coercive.
I think the issue has to do with, what does a lay person, an uneducated person have to say to indicate that he doesn't want to talk anymore? That's his right, even in the middle.
If you accept the premise that we believe that, or that I believe that this was an equivocal statement on the defendant's part, where does that take you? I mean, an equivocal statement, I mean, there used to be case law years ago that you could clear up the equivocation, but you don't even have to do that, as I understand case law now. So what could the police do if we say this was an equivocal statement on the defendant's part?
Well, the law is clear. It has to be unambiguous and unequivocal. I mean, there's nothing equivocal about it. Equivocal
how about
means
Owen?
hesitating. There's
Owen
nothing.
had the 2 statements, I'd rather not talk about it, I don't want to talk about it, and in Owen, those were held to be equivocal, weren't they?
In what case?
In Owen.
Yeah, about it and about that in response to, did you plan this? Did you plan to go in this house? And what did you do with the bicycle? So those were very specific questions about the circumstances. There was no specific question here, and there was no about that. It was simply, I have nothing to talk about. And the cases, I cited probably about 6 or 7 of them with very semantically similar statements where the court said, you know, this is an assertion of the right to silence.
Which cases, were those after Davis of the US Supreme Court?
Yes,
Okay,
yes.
so what cases from, first let's start with our court, because I wasn't able to find any where a similar statement was held to be, because I think what Justice Quince was asking you was that this held, first of all, to be unequivocal, because you've kind of, I think, agreed that if we consider, and this is a mixed question of law and fact, this to be equivocal, you're out.
Right, I
Okay,
agree
so
with that.
What case is similar to this? 'Cause I thought, when I agree with what Justice Lewis said, I thought that was similar and we held it to be equivocal. What case do you think is similar to this that you said there are several that hold this to be unequivocal?
Well, there's no case from this court, but
Okay.
there's the Douglas case, Reed case, Christopher. I got nothing else to say. I have nothing to say. Really, I ain't got nothing to say. That's Martin. I think that's a district court case from Florida. I have nothing to say. I have nothing to say. I'm not saying anymore.
And those cases are from what court?
Well, Smith and Martin and Pierre are all district court cases in Florida.
I mean, are you talking about a district court of appeal or a federal?
District Court of Appeal, yes.
The last statement that you read was, just read that last one. I'm not saying.
I'm not saying anymore.
All right, now, do you not see that statement, and again, is a stronger statement than this statement? I'm not saying anything more, which is, I'm not talking anymore.
I think it might be a little stronger, but I still think, and this court and the U.S. Supreme Court has said there aren't any magic words. There's no talismanic expression the defendant has to say. They simply have to indicate they don't want to talk, that they're done.
So are
And
you
he
even
says, I
saying
have
that-
nothing to talk about.
So at that point, what you're saying, the rule of law would be that the police could not even ask a clarifying question. Are you saying you don't want to continue this interrogation? They would just have to cease the interrogation?
I think if a defendant says, I have nothing to talk about, that is crystal clear, unless the context indicates otherwise. There are cases where a defendant has said something like that, I have nothing to talk about, I don't want to talk, and then they continue talking. That's
Well,
the
didn't they-
other
Well,
exception.
didn't they continue talking here? Didn't he continue
No,
talking?
I mean, before
What
the-
happened between an hour, I just thought, between an hour and then you said it was another 2 hours. He didn't say anything in those 2 hours?
What I mean is when they continue talking immediately following the assertion, like
Without
in Pierre.
questioning.
Yes,
You're
like he
talking
says,
about continuing to talk without any questioning from the police.
Exactly.
But that your assertion then is that the police, if we say this is an unequivocal statement, the police cannot say anything else to him, and they have to cease anything.
right, the police have to stop. He said he doesn't want to talk. I mean, the other cases involve someone who says, I don't want to talk about this, but, my girlfriend was there and the other guys really did it. That's equivocal.
So if he begins to talk on his own, that's what you think the state of the law is.
Yes, and there's cases that support that. The Pierre case is a case in Florida, District Court of Appeal case in Florida, and other cases. But if he just makes a statement, in this case he made the statement and he sat mute. He didn't say anything. The detective immediately confronted him with it. Well, it doesn't look that way. Your body seems to be saying something different. He says, well, I'm under a lot of pressure. I mean, that's the exact type of coercion that Miranda and his right to say, I don't want to talk
Is there a
anymore, is
difference
designed to
between-
prevent.
Is there a difference between saying, I don't want to talk, and saying, I really have nothing to talk about?
I don't think so.
There is not. Okay.
I don't think so. I mean,
But what it seems the difference to me is when you say I have nothing to talk about, you're indicating that you have no knowledge, or you're referring to content, or I didn't do anything that I would have to talk about. So that seems a much different thing than to say I don't want to talk, period, about anything.
see, here's the problem. Unless you accept the words at face value, you're getting into playing games with language. I mean, we're
Well, I
not.
don't know that we are, though, because what we're really, we want to, and I, you know, I feel pretty strongly about making sure we have some clear rules for the police, but I guess I'm saying to you as an ordinary, you know, trying to understand the ordinary meaning, and I agree that the idea whether the talk is first or second, that I would not fault the police for not understanding that what he was saying was, I am now, you know, the equivalent of I am now invoking my right to remain silent. Now, I agree he doesn't need to say those magic words, but to me, it's much more likely, as Justice Polson just said, that it is more of the idea that I'm innocent. Why do you keep on asking me these questions? Which, I said before, I think, I'm not an expert in interrogation, but I would think most of the lengthy interrogations start out with a defendant who is telling the police that they don't know anything about it. Why are you bringing me in? I'm innocent. I have nothing to tell you. And that's not, if we said that, we would have to cut off all, you know, interrogations when they're proclaiming their innocence, saying, I don't know about this. I've already told you. I don't know where my girlfriend's body is. I have nothing to tell you about it.
I understand your point, but again, you have rephrased what he said. He didn't say, I don't know where the body is. I have nothing else to tell you about that. He said, I have nothing to talk about. And that's different. And honestly, I don't see a problem with teaching the police that if a defendant during questions says, I have nothing to say, I have nothing to talk about, that's when you got to back
You know,
off.
I probably could understand it a lot better if this is the statement he had made at the beginning of the interrogation. If he had said, I don't have anything to tell you at the beginning of the interrogation, but this is an interrogation that has gone on for a while. I mean, they've discussed several issues, and so I think it makes a real difference that this took place at that point in the interrogation.
I think it can make a difference, but again, it depends on the context and what the remarks are in response to. The words.
Do we look at this from the perspective of the officers who are doing the interrogation as to what they would have reasonably understood concerning his invocation of his rights?
Yes, it's a
Okay,
reason.
so you've got to look at that, as Justice Quist is saying, you've got to look at it in the context. And when this suspect has been talking to them and, you know, going through what they've been going through, it seems to me that given that history of their interaction, they're going to think, well, he's just saying he doesn't want to answer that particular question. He's not going to say anything about that. But
There was no question, Your Honor.
But that's a very different thing than saying, I don't want to talk to you anymore.
Again, you're suggesting that he has to say magic words, and there was no question here.
I'm saying that we've got to look at it in the context. I think there are any number of formulations that could be used that would communicate to the officers that this interrogation is over, and because I'm not going to talk to you anymore, but that when you look at it in the context we have here, that they would not have reasonably understood that he was unequivocally asserting that.
Well, a couple of things, Your Honor. They did understand that because they argued with it. And number two, I think what you're suggesting is imposing a standard on the defendant for asserting his rights that's already been, that is against what the Supreme Court has said. You know, in any manner, if in any manner. And also...
As long as it's unequivocal.
Yes, and these words are unequivocal. These words are unambiguous, and there's nothing about the context that suggests otherwise. What I'm arguing is, if there's something in the context, if the state can point to something in the context that suggests ambiguity, then that's fine. But there is nothing here that suggests ambiguity. There was no specific...
You asserted a number of times that there was no question that was asked when he made the statement. What did the police say to him that invoked that statement?
They said...
exactly.
Get it off your chest. Hang on just a minute. It's a weight off, man. It's a weight off. It's a relief for you to be able to lay down tonight in your bunk, knowing that shit's behind you. And he says, you know what? I already feel that relief. I already told you what I told you. I have nothing really to talk about. Following on that, in context, he's saying, I have nothing else to say. I don't think there's any other reasonable interpretation of it.
But you don't see, I just pulled up Pierre. In Pierre, the defendant said, I'm not saying anymore. I'm not saying anymore. He then remained silent for nearly a minute. The defendant, the detective himself, didn't say anything, and then changed the subject. Now, I guess I'm going to just, you know, I need to look up Martin, but it seems to me that I can agree with Pierre that that is a, I am not saying any more. I'm not going to talk to you, as opposed to, I don't know anything else I can tell you, which is, and I think that's a distinction. I guess some of my colleagues do too.
But he didn't say I don't know anything else. He said I have nothing to talk about, which is identical to I have nothing to say. I mean, I think my fear is that what you're suggesting is that he has to say it over and over, that he has to fight these people in this high-pressure situation. When they're arguing with him, when they're telling him, hey, that's not what you mean, we're looking at you, and, you know, your body's not saying that. And that's not what the law is.
But the problem that we get into is if something requires interpretation, then how does one say it's unequivocal? Because that's just the argument that you just made, that you have to interpret this phrase to mean that. And if there are more than one possible interpretations of it, does that not render the statement ambiguous or equivocal?
If there are more than one interpretation.
Well, you just made the argument that we have to interpret this to say that I don't want to talk to you anymore, when that's not what these words say.
Well, they do. I have nothing to talk about. I'm saying that's what they mean at face value.
Okay, well, you previously said that means something. And again, so you would agree then that if this is subject to a reasonable police officer hearing those words, if it is susceptible to more than one interpretation, it is not ambiguous, or it is ambiguous and is equivocal.
Yes, and my argument would be that the words are not subject. There has to be some contextual reason for making it ambiguous.
Could you address your argument about the content of the other things they said to him about the chair, the electric chair, as I recall? They made comments about that. Would you?
Yes, and that's our second argument, of course, that his statement was involuntary, that it was a product of coercion. And I've outlined, I guess, maybe 6 categories of types of coercive or deceptive tactics that the police use, all of which have been condemned by this court, by the U.S. Supreme Court, by courts all over the country. And in some of those cases, there was only one statement made, and the court said that rendered the confession involuntary. In this case, not only do we have 4 or 5 different categories of coercive statements, they're repeated over and over and over again relentlessly throughout the interrogation.
Is there, for example, with regard to capital punishment, is the rule that police officers cannot mention what the possible outcomes are during an interrogation, or is it that law enforcement cannot use the fear tactic of capital punishment, or is there a distinction between the two?
There is a distinction, and the latter is forbidden, the former is not.
It's not, okay.
It's not considered
And so
coercive.
here you say this is fear, not a discussion of possible alternatives that could happen as a result of this interrogation.
Correct, and
Okay.
it's tied to whether he confessed, and that's also what makes it coercive.
In terms of, let's take it from where, now you're going to be out of your time shortly, but just quickly as to, from the time that he said, I have nothing more to tell you, and he was protesting, he didn't know anything, till he confessed, were all of those tactics that you say, your Christian, a variation of the Christian burial, all that, were those all done within those 2.5 hours? How did, in point of time, did they occur in the interrogation? And for us, do we need to look at that whole interrogation to make sure, and was this interrogation videotaped?
It was videotaped.
So we
and
could watch it to see?
You have it, the whole thing, yes. I'm trying to recall, I think that most of those statements came after he said he didn't want to talk anymore, after they confronted him with they had some cell site data that indicated her phone had never left Clay County.
Well, there would be no problem with them confronting him with true evidence of how they found that he was involved.
No.
Okay.
There's no problem with confronting him with true evidence. And in some cases, even when
untrue evidence.
even when the police have deceived the suspect about the strength of the evidence that they have, the court has in some of those cases said that it's inappropriate, it's not approved, but it's not coercive, not compelling enough to render the confession involuntary. But in this case, there's the threat of the death penalty, of the electric chair, of life in prison, and the other statements that I think were the most egregious were the many, many statements that assured him. They told him he gets the death penalty if he doesn't confess, but if he does confess, he's not facing the death penalty. He's not really facing the death penalty. If all he did was, if this happened because he wanted the car, and of course that's exactly what happened.
But what they're saying is, if this happened accidentally,
No.
you're not going to face the death penalty.
Well,
if it was isn't that really what they were saying?
No, there were many statements that weren't just accident. They said if you wanted the car and things blew up, you lost control, you busted loose, then that's not a death penalty case. You're not facing the death penalty. They told him that pretty clear. And again, they drew a diagram with premeditated murder at the top and other lesser offenses. We don't have the diagram, but they kept saying, you're not at the top of the tree, you're at the bottom of the tree. Big difference between premeditated, planned, first-degree, monster, cold-blooded murder to the other end. It wasn't planned, a lot was going on, I was busting loose at the scene.
But isn't that true? I mean, isn't that true that if something blew up, as in this case there's CCP, which I know you challenge, but assuming that it's CCP, then isn't that true that changes it from a spur of the moment, I lose it? I mean, isn't that a correct statement of the law?
It's not a correct statement to tell someone that if they commit felony murder, they're not eligible to the death penalty. And that's basically what they did. If you did it just to get the car, and we all know that's first-degree murder, it's an automatic aggravator. That makes him eligible for the death penalty. They implied not only would he not be eligible for the death penalty, he'd be getting out of prison. You have a future with your girlfriend. You're going to be going to movies with her. You're going to have kids with her. You've got a long life ahead of you. This was relentless, on and on and on and on. And of course he believed it. He's talking to two, as they told him themselves, respected law enforcement officials who said, everyone believes us. What we tell them, they'll go with. And at the end of this, he said to them, I'm probably not going to get out until I'm 50 years old, huh? So he's thinking he's going to face a long sentence, but not the death penalty, not even life in prison. And that sort of deception, that sort of delusion is the kind that distorts rational choice, which is the definition of voluntariness. Is my time up?
You have exhausted all your time. I will give you an additional minute and a half. You've exhausted all but about half a minute, so I'll give you an additional minute and a half.
Thank you, Your Honor.
Assistant Attorney General Charmaine Millsaps, may it please the court?
Can you address because it's the coercive questions that I'm concerned about. I'm not as, it does seem that there is sort of every, quote, trick in the book was used. Now the question is whether the bag of tricks together equate with the kind of coercion where his will was undermined or overborne by the police techniques.
Well, Your Honor, first sort of big picture, I would sort of like to answer your question. He's given Miranda at the very beginning. He confesses at the very end. This is almost 4 hours. Yes, the DVD is 4 hours, but they take breaks in between, okay? But none of those comments are even close to the confession at the end. It's he wanted to talk to his girlfriend. That's what immediately precedes the confession. He wants to talk to his girlfriend, and he said the two detectives, who, remember, one is from Jacksonville, JSO, Detective Wolcott, and then Detective West, who's from Clay County, said, this is not my jail. Their standard policy is to not let you talk to him. But we'll see if we can arrange, a visit because she was having trouble with her ID. That's what happens before. All these statements.
Do you concede that after the police had said something to the effect, you need to come clean or you're going to get the chair? That's a reasonable interpretation of what they said, or something along those lines. That if he then said, I did it, would that be a problem?
Yeah, sure. Let me make it a little stronger, but I think that would be a problem. If you basically said to a suspect, if you confess, you won't get the death penalty, that's going to be a problem if he gets the death penalty, if he immediately confesses. But that's not what happened here. Both not what happened here in terms of statements nowhere near that clear were made.
What did they say? What did they say about the chair?
They said monsters go to prison, monsters go to death row. It was really more to try to get him, and at another time they say, you're not a monster, be a hero, tell us where she is. They were doing monsters versus heroes, okay? So that's sort of a theme through this. But none of that even, he didn't, and then let me go.
Is it critical to the decision as to whether these are coercive, that it has to occur right after the statement, or do we look at the totality of the circumstances? Now, I think the favor is that this is a relatively short interrogation, as interrogations go, a 3 or 4 hour interrogation, and we've seen them day or, what time of day was this?
It was 12:58 when they signed the Miranda, right at the very beginning. And that's the first thing you're going to see on the DVD.
It's afternoon.
Yes, yes. This is down in Pinellas County Jail. These detectives have come down to an interview room. It's 1 o'clock in the afternoon, and then it lasts, and at one point they even say it's 3 o'clock. It lasts from basically 1 to 4.
So is the statement about you're not a monster and, if you come clean and this was spur of the moment, you're not going to get the death penalty, was that said only once or was that repeated?
I would say there were two references to that, but Your Honor, now, if you're talking about monster part, the monster part goes on, but it's monster versus hero. It's not the death penalty part, okay?
But I thought it was monsters get the death penalty, heroes don't.
Right, but you're asking me what was repeated.
Okay, but that was repeated too, monsters get the death penalty, heroes don't, and did they say to him that if this was you were just wanting to get the car and this was more of a spur of the moment, that you won't get the death penalty?
No, Your Honor, that's exaggerating what happened. They said, we understand you didn't want to you weren't after JC, you were after the car. They did say that, but they didn't say, and therefore you won't get the death penalty. They didn't say that. There's not that second part, okay?
What they said, the detective says, the best thing that David can do for David is to help us find JC.
Yes.
And then the detective then goes on to say, because you look like a monster if you don't. You really do. And you know where monsters go. Monsters go to prison. Monsters go to death row. Monsters never see the daylight again.
That's what they said.
That was the exchange.
Yes, that was the exchange. That was the exchange. And now, Your Honor, for example, take the monsters go to prison part. He then at one point says he knows he's facing life later on. But, so a lot of this, and this occurs in the middle as well, and he tells him a story after that about her just getting out of the car and his just driving off. Okay? So I don't think, of course, a false story.
He's 21 years old. Now, he's not 17. He's not a Ramirez. But
yes,
he's 21, and if they have, and again, I guess it's looking at this whole interrogation is important, but if they tell him something that leads him to believe that he's not going to be eligible for the death penalty, is that a problem?
I think misrepresentations of the law would. Now, Your Honor.
Isn't what Ms. Kerry said that felony murder can if there's felony murder, that still makes you eligible for the death penalty?
That's true, but Your Honor, if that's the only aggravator on the table, the state doesn't even.
On the head with a hammer. I mean, you're going to have.
They didn't know that at that point. Remember, yes, they're homicide detectives. They suspect this girl who hasn't been home for 9 days that something's happened to her. They did not know that she was hit. We now know what he did. So we now know that, yes, he is eligible for the death penalty. But the detectives sitting there talking to him do not know that. They don't know anything about hammers. It's only at the end that he tells them about he hit her with a hammer. All this happens before. Your Honor, they don't know where she is. They know she's missing, and somebody who hasn't been home for 9 days, who always goes to work. That's not good. They think something's happened to her, but they certainly do not know that he killed her with a hammer. It's only at the very end that they find that out.
Put it in context. It seems to me, from reading the transcript, that the whole issue came about in talking to him about that they did not know what happened, and only people convicted of first-degree murder get the, quote, damn electric chair. But they were talking to him about whether or not perhaps what happened was something in line with second-degree murder, where people would not get the. I don't know, from what I'm reading of it, that there was a promise that you're not going to get the electric chair.
See, I don't think there was a promise. And secondly, Your Honor, remember, we now know which, they used a tree, and we now know that he is at the top of the tree. But the detectives, when they're using that analogy, they don't know that he's at the top of the tree, because they don't, the facts that we all are now relying on, they didn't have until the very end. They're making these statements, they do not know she was hit with a hammer to the very end when he tells them that. Okay, they do not know any of this. They don't, so the only thing they know, he wanted the car, but they don't know if they don't know what happened until he tells them at the very end.
Is that important too in deciding about whether this is coercive? That is, that if his confession had been less than truthful, which is he tries to mimic what they say, she tried to leave, and But does he tell pretty well what the eventual
He tells
facts are?
he tells 3 stories, and that's why I think this is important. The first one is nothing happened and I just dropped her home and borrowed the car. The second one is, and the second one comes after some of these statements that we're talking about. He tells a false version of what happened, that she just stepped out of the car and I just drove off. And he denies even hurting her or hitting her with the car or anything. She should be by the side of the road at a horsetail. And they said, come on. That, you know, that's ridiculous that there are a lot of houses around that area. She would have walked. Everybody knows 911. They say everybody knows how to dial 911 since they're 5 years old. So they tell them they don't believe that version, okay? And then they talk about the girlfriend, and then that's when he tells them that he tells them the correct version right at the very end, which is he told her he was going to get a cigarette. He got a claw hammer out of the car and hit her. And he admits hitting her once and hitting her again, but he doesn't say how many times she was hit. She was, in fact, hit anywhere between 7 and 9 times with this claw hammer. Okay, so he admits hitting, then dragging her body to the palmetto bushes, and then taking the car down to St. Pete. But all of that is literally at the very end. So remember what we do have, and I do think it's important, the context here. At the very beginning, we have Miranda read. We have an hour of his telling just general whereabouts, what happened that night, where they went, all this kind of stuff, with the lie at the end about just taking her back to Jacksonville. They then confront him with cell phone records proving she did not go back to Jacksonville that night, that her cell phone, he took her cell phone when he took the car. The cell phone headed down to St. Pete in the car with him. So they're confronting him, you're lying, with cell phones, and that's their evidence, the cell phone records. And they explain cell phones and how they do it with the towers so that we know where that cell phone was, okay? And then, even after being confronted with that, he tells what I call the horsetail story about just driving off, getting her to go out of the car, yelling and screaming at her to make her go out of the car and just driving off, leaving her perfectly fine. And then they tell him that just makes no sense, which it really doesn't. And then they talk about the girlfriend visiting. Now, I would like to, and then that's when he tells them the real story about what happened that night, about he told her he was going to get a cigarette. They were by Clear Lake. Incidentally, he's from Middleburg. The state's theory is he took her to this, desolate area, and on purpose. And because he knew that area and he used to swim in that lake, he grew up in Middleburg. So he took her there on purpose, and then he went to the car, got this claw hammer, came back and hit her on the head. He admits once, and then he says, and yes, I hit her multiple times. I can't remember how many, okay? And then they go to the car. So even with all this that we're talking about, all he really does is tell him the horsetail story is, that first version of I just drove off and she was fine, okay? So it's not to the very end that he then, so this did not coerce. Yes, Your Honor, I do think it's important to know it's not just a matter of right immediately, but if for hours go on and you're telling a second version that isn't the truth, I don't think that's very coercive. They did not know what degree it was. If they knew a lot more about the crime and misrepresented not the facts, but the law, then, Your Honor, you do have a problem at that point. Okay, I'm not saying interrogations can't be coercive. Of course they can. And one of the big things to look at would be misrepresentations of law. But you cannot do what we're doing here, which is after the fact, when we know what the correct facts are, so we know which correct law applies, say that the officers who do not have any of those facts are misrepresenting the law. They didn't know that.
How about the injection of religion into the interrogation? Certainly didn't use the magic words that are prohibited, but certainly utilize the concept, the morality of religion, the feelings of this mother, and give her back to her mother.
Yes, Your Honor, I mean, they did at one point invoke the Bible, and they said, I'm not going to give you a Bible lessons. okay? But they didn't, and this was very much a tell us where she is so we can give the mother's closure speech. But that's different from Christian burial. But yes, Your Honor, it is a plea to his conscience about the pain that this mother is in.
And the
I personally do
suicide
not think that's coercive in the least. I think that's just...
How does a court look at all of these? Because as we go through, there are 6 different elements that the defendant says you walked along the, if not crossing the line of propriety, you certainly were right on it. And do we look at this as just each one independently, or do we look at cumulatively how this interrogation, because then you're asking us to look at it cumulative. Wait, we didn't know during the interrogation, which is true, what had happened, but each one of these really walk the edge, it seems. And then the question is going to be, do they step over? I understand that, but at least the subject matter and topics that have been prohibited are approached multiple times in this interrogation.
And, Your Honor, you do look at them all together. State's argument is not, the law's clear. It's a totality. I necessarily need to talk about them individually because I need to do that, but no, but I would like to get a couple of them clear because I don't think they exist at all. The disappear comment. Cases like this disappeared. That's not what was said, Your Honor. And at one point, they say justifiable and excusable cases can disappear. Justifiable, excusable. But at another point in the interrogation, they tell him this case, your case, is not going to just disappear. Okay, so I think disappear is off the table. I just don't think that's just not a valid. I don't think you can read this interrogation and get the impression that this defendant thought this case was going to disappear. He was directly told his case was not going to disappear. And at one point he says, he's facing life in prison. So he was not there. We can discuss life versus death penalty, but the idea that he thought he was going to walk out of that room was just, he clearly didn't think that, Your Honor. His own words out of his own mouth show he didn't think that. He knew he was in serious trouble. The detectives at several points tell him this is the biggest day of your life. They do tell him that this is important, okay? So some of I don't think all 6 are valid, Your Honor, okay? So some of them, I think, just fall off the table. Such as the disappear comment. I don't think there's anything, that's just not accurate of this in totality. And then the other one about, the other one that I thought, now I would like to talk a little bit about the girlfriend, because to me, that's the one that precedes his confession. So,
the visit?
Yes. So I would like to talk about that one because that is, in a timing sense, one of the more important ones. So I would like to tell you what happened regarding that. They tell him that Pinellas County, he wants to talk to her. He asked, just like in Baker, I did supplemental authority of Baker. He asked, which this court recently decided, involving a girlfriend and a confession, and it was the defendant's suggestion here, just as in Baker. He wanted to talk to his girlfriend. The detectives explained that Pinellas County has a policy that they can't do cell phones. They won't let him talk to her. But we can arrange a visit. What was happening was she was having trouble because she didn't have identification because it was in this victim's car. Her ID was. She was having trouble getting into the jail to visit him. Okay, so they say, well, we can make arrangements. Now, what happens though, they never promised that they would they never said that they would take Erin against her will down to see him. Erin's, his girlfriend, Erin Urban's half-brother is an officer, and she was crossed during the trial, and they said, your mother and your brother, half-brother, did not want you to see this guy anymore. They gave you a lot of grief about him. That's how they found him. the mother was suspicious of David Martin being down there in the first place and had the half-brother, who was an officer, run the tag. That's how suspicious. They did not want her near him. And so it was her choice, Your Honor. If you read everything in this record, her cross and things, and defense counsel. So, Your Honor, I don't think they... Yes, the visit did not occur, but it wasn't really in their control.
That's all very interesting, but did the officers have that information at the time that they were making the statement to the defendant about the visit?
They did know she was cooperating with them. Yes, they did. Her
did
brother.
They know that the brothers, whoever it was, did not want her to actually visit the defendant? Because it seems to me that this is some information that they gained later, and it really, how relevant is it to whether or not they were making a promise to him about getting her to visit?
Well, they did know that her brother was an officer and that she was cooperating and giving letters.
The question is, did they know that he did not want, brother did not want her to come visit? That she did not want to come visit.
No, I don't think they knew that then, but that's part of my thing. They were saying, look, we'll take care of the ID problem. And they thought that was the only problem. Turns out there was a bigger one. She didn't want to see him. But I don't think that makes that false. When I tell you I'm going to fix the paperwork, and it turns out the paperwork's not the problem.
Did they use that statement, that we're going to fix the paperwork?
No, they said she was having trouble with an ID. They do reference the ID. She was having trouble getting into the Pinellas County Jail. They do talk about it during this time, about her having trouble getting into the jail because of our ID.
The concern I have about that exchange, and it went like this: Detective, I believe Urban is trying to also get a visit. Defendant, are they going to let her have one? Detective, oh yeah. Second detective, yeah, we can see it. We can make the arrangement for visits, okay, but we got this issue right now, David, that we have to cover first, okay? Then the second detective says, just tell me where I can get JC. I mean, it sounds to me like they're telling them, tell us where we can find JC, and we'll make it work so that Urban can see you. That's what it looks like to me.
Okay, but now remember, Your Honor, in Baker, this court's recent decision of Baker, you've said if the defendant suggests, I'll tell you, but let me see my girlfriend, that's fine. I mean, this court's case law, very recent case law, says that if the defendant wants to see a girlfriend and you let him see a girlfriend, that doesn't make the confession coerced or involuntary.
That may be the law, but the exchange, though, it seemed to me, was that he wanted to see her, she couldn't get in. They're telling him, okay, tell us where JC is, and we'll make it happen. It sounds to me like that's the quid pro quo that they were suggesting.
Okay,
and that may be admissible, I don't know, but...
Yeah, see, I don't think that's a problem. I don't think I disagree about what's going on there. I'm just saying that's not a problem, and this court has held that's not a problem. You did that just recently in Baker. The defendant wanted to see his girlfriend. The police said, we'll arrange that, but first, we've got to talk. That's pretty much exactly what happened in Baker. So that is not a problem, and this court is so held. Okay?
Just before you are out of time, I wanted to ask about the aggravating circumstances. The judge found as one of the aggravators that he was previously convicted of a felony and he was on felony probation.
For burglary.
And gave that great weight. He took his mother's air conditioning? Is that the burglary?
Yeah, I think that was...
It's a third-degree felony.
Yes, he was.
How can we look behind that to say, why would you give that great weight? I mean, if he's on probation for having committed an armed robbery, or he had a prior violent felony of a murder, but he took his mother's air conditioning, if that was, I mean, let's assume, and I know it's not, but let's assume that was the sole aggravator. You'd agree that that's giving it great weight looks like, how can you give it great weight? So do you agree that that probably is he weighted that more than we would expect if you take every kind of felony probation and look at this one? This is not violent, this is, I don't know the circumstances of why he took his mother's air conditioner. I assume it's a air conditioning unit.
Yeah, I don't know anything about air conditioners.
Well, we don't know anything, but what would make it great weight, I guess, is my question to you.
I think it was the fact that he was currently on probation. It's
Well,
that.
that's found as an aggravator. I'm not questioning it's an aggravator. The question is, we're looking at issues for proportionality. I don't find that to be a compelling aggravator. Now, the one I do want to just make sure, and I think I agree on this, but I think it's critical, is CCP.
All right, Your Honor.
There's no question that he wanted this car.
No question.
What is it that shows, and I think the judge found it, but I just want to make sure that he went there with the idea not only that he was going to take her car, but that he was going to kill her?
Because there was a phone call between Erin Urban, the girlfriend, and him. If you look at the cell records, where they talk about he's going to steal a car. This is his part. He's going to steal a car, and she says, "Well, then what are you going to do with the person who owns the car?" And he says he's going to kill him, and then she jokes back that, and she says she thought this was a joke, but that's her perception. It clearly turns out not to be a joke. This conversation, that if you narrow down the phone records, it occurred on March the 8th. This murder occurred in the night of March 11th.
But we
okay,
also
that's days
we have that
before.
Conversation. We have that he takes, is the claw hammer, which was the murder weapon. Where did he get the claw hammer from?
Well, Your Honor, I won't want to be forthcoming about the record. That's a little unclear, Your Honor. She did have one in her car, but that's not the murder weapon. He was a construction worker person. He had a toolbox and stuff like that from being construction worker. He probably either took his entire toolbox with him on the car that night, or because he talks about getting the hammer. So he's brought the hammer, Your Honor.
But this is somebody that he knows and he's friends with, right?
Right, and so he's saying,
if he wants to steal the car, he could take her out, then go outside and just take the car. I mean,
yes, he can, and he did not.
What you're saying, and I think the judge found, he takes her to an isolated area
that he knows that she does not.
Right, and then he gets the car, the hammer, and comes back while she's just.
They're just sitting out there looking at the lake. There's a clear lake back there. It's at an end of John Cemetery Road. Turns out John Cemetery Road doesn't have a cemetery on it.
So the idea is does the state argue, and the judge found that his intent at all times when he brought her out there was to kill her?
Yes, and that's what the judge found, so that's why the CCP. It's that the conversation about stealing a car and killing the owner of the car occurs days before this.
So
he then makes these elaborate 31 messages, text and phone, go back that day between the victim, JC, and the defendant.
Okay, so there's CCP, and then there's in the course of a robbery. Is this the case? I know we had one today. Did the judge do a special interrogatory in this case to find him guilty of both premeditated as well as, that's not this case? We had one this morning that...
I don't think that's this case. Now, the state did give notice of aggravators here, Your Honor. That wasn't raised as an issue, but the state gave notice of aggravators, not just of death penalty, but of aggravators they were seeking in this case. Okay? So we do think CCP is highly, so even if you, typically, Your Honor, you all don't reweigh things that when
Well, I
when you
know
give
if
an
we
a-
don't, if it involves factual circumstances
Oh,
that we
okay.
might not have.
Okay.
But that's why I asked you, is there anything more than he was on a third-degree felony probation for
No,
taking his mother's
well, no,
equipment?
I mean, he was, for instance, he's down in the Pinellas County Jail for retail theft. He does have, but it is, they even
I'm
refer
not
to it as
challenging it's an aggravator. I was just
Sure.
the weight, it seemed,
Sure.
that I've said many times, that I think prior violent felonies, if they are truly, if it's a violent felony, and it was murder, robbery, that's a very significant aggravator.
And I wholeheartedly agree with that, and then the contrary is necessarily true. I see that. But we do think that the main aggravator here is CCP, which this court has also repeatedly said, just like HAC
Well,
and
he did
prior
it for
violent.
pecuniary gain, and it's, I mean, which
Yes.
is also an awful, I mean, the whole thing is a terrible thing.
Yes,
As
yes.
they all are, but this has these particular aggravators that make it, as the judge
Yes, so we
found,
do
beyond
think
the
that
norm.
CCP would make this a death penalty case, given that he was, you know, even no matter what the weight, he was on probation, and he did have this history. Thank you, Your Honor. We ask that you affirm the conviction and sentence.
Oh, I just have a minute and a half. Just a few brief comments going back to the
2 minutes.
2 minutes.
You had the 30 seconds you had plus a minute and a half.
Thank you, Your Honor. One thing the state has said here is that he knew he was facing life in prison, and that's, I don't think, accurate. And I'd just like to read a couple of the other comments. The detectives told him after they set forth that if you don't confess, you're going to get the death penalty. They mentioned monster probably 15 more times. Are you going to be the monster? Are you going to tell me how I can take you home? Don't be the monster. Tell me where she is.
Where did they say if you don't confess, you're going to get the death penalty? That's your paraphrase?
Yes.
Okay, so they never actually said that.
If you don't tell us where she is, you're going to be the monster. And they've said monsters get death row. So I think it's implied. And the other end of it is, well, but you're a good kid. You have a long life to go. There's a future. This is just some minor little shit that can be taken care of. Let me tell the jury that David did the right thing. He got into a situation he couldn't control. There's a safety net. Big difference between, I think I read this one before, planned first-degree murder, and it wasn't planned. A lot was going on. I was busting loose at the seams. We haven't lied to you. Everything we've told you is the truth. David is not a premeditated murder. Those people go to the electric chair. All you wanted was the car. You are not the monster. You are not at the top of the tree. And this is the one in particular I wanted to mention. The detective says, do you want your fiancé to hold your hand and go to the movies with you again, or just stand behind a piece of glass talking on the phone? And Martin says, that's all she's going to have. And the detective says, no, she's not. That's what you're not getting. That's what you're not understanding. She's going to have that if you keep up with the lies. She's going to have that if we have to portray you as the person that has told everyone to fuck off. In other words, if you don't confess, that's what's going to happen. I think it's pretty clear. And then we haven't talked about the last chance comments, but I think those are also coercive. It's getting dark. Tell us now, or that's it. You can't talk to us
these,
again.
I mean, in fairness, can we not take into account that these were officers from other jurisdictions, and they were not going to be there in the county where he was being held? Isn't that true?
That may be true, but they're telling him.
They were, well, as I read that, and I find that one of the weakest ones, because they were going back to Duval and Clay counties, and they said, we have other duties, we're going to be assigned to other things, and if you want to tell us, now's the time we're going to be leaving. I mean, and that, to me, was a correct statement.
Once I leave, you're a monster. I won't have another no, it's not correct. They had a VOP warrant for him. They knew they were bringing him back up. I disagree with you. And I think you have to look at it in terms of how a reasonable person in this suspect's position and interpret it. And I think that's what the law is. Thank you, Your Honor.
We thank you both for your argument. The next case on our docket is Tanzy versus the state of Florida. The court is still in session.
Good morning. May it please the court. My name is Paul Callow. I'm Assistant CCRC South. I represent Michael Tanzy in this appeal of the denial of Rule 3.851 relief. I would like to focus this morning on Mr. Tanzy's claim of ineffective assistance of counsel at penalty phase, on which he was granted an evidentiary hearing, and specifically about the issue of the 47 XYY syndrome. I want to be very clear about what 47 XYY is and what it is not. It is not the criminal gene. It does not automatically make somebody a criminal. If it did, I would be up here arguing insanity, and obviously I'm not. What it is a fundamental chromosomal disorder where Mr. Tanzy's genetic makeup is different than any other 1,000 males.
Now, as you tell us this, can you tell us who in the evidentiary hearing told the judge about this?
This was Dr. Carl Mensch, who is a board-certified geneticist from the University of Miami. And he explained to the court, again, that in the 60s and 70s there was a belief that there was some criminal gene, and this XYY syndrome was blamed for criminal behavior. The more recent research has retreated from that. Dr. Mensch explained that the 47XYY syndrome is a confluence of symptoms and signs that result in an increased risk for certain behavioral and developmental problems. Not everybody with 47XYY has all of these symptoms and signs. Some people are going to have more than others. I think in Mr. Tanzy's case, it's very clear that he shows just about every sign that Dr. Mensch discussed at the evidentiary hearing. It's evident in the record. It's also evident based on the records that were submitted at the evidentiary hearing and at trial that he is the phenotype, the physical manifestation of that genetic disorder.
Can you just tell us just exactly what you claim this XYY thing would cause someone to do? What is it that, assuming the worst case scenario in your client's case, what is it that it caused him to do?
It didn't specifically, XYY didn't cause him to do anything.
So how does it play any role in this?
What it did cause is the developmental and behavioral problems that he exhibited. Now, again, if I were to come to this court and argue that XYY caused him to commit this crime, we would be talking about an insanity defense, and that's not what we're talking about. We're talking about mitigation. 47XYY causes the kinds of behavioral problems that were attributed to antisocial personality disorder.
So urges that he may have had?
Impulsivity.
That's what you're getting at?
Impulsivity is a very good example of the types of behaviors for which people with XYY are at increased risk. Others would be being overly emotional, being withdrawn, being socially maladapted, unable to make friends. As a matter of fact, Dr. Mensch mentioned that people with XYY often will create conflict with other people, especially children. But this is exactly the type of behavior that Mr. Tanzy was involved in as a child, starting from a very early childhood, where he would pick a fight with the other neighborhood kids and then retreat and cry and not defend himself. This wasn't so much an act of necessarily aggression as it is a manifestation of these behavioral problems due to this disorder.
Now, you're saying, did Dr. Mensch say that? Did he take what he explained to be the gene and what they know about that gene and what they don't know, and then say, now, with that overlay that he had this, when we look at his behavior at age 8, which is when was the beginning of the sexual abuse?
Around that time, right.
That we now look and say, not only was it a result of the sexual abuse, but it was likely a genetic predisposition. Does Dr. Mensch or anybody give that scientific statement life for this case?
Well,
because you're doing a very good job of giving it to us, but what our job is to look at it and say, does it undermine our confidence in the outcome because this overlay was not in front of the jury?
A couple of things. You asked about anyone. At trial, the experts did testify that there was a genetic component to antisocial personality disorder and some of these other behavioral issues. What they weren't aware of was the fact that Mr. Tanzy does in fact suffer from this disorder.
Did they testify at the evidentiary hearing that if we had known this, that this antisocial personality disorder, which is, although we allow it as mitigation, is never really given much weight, would now a jury would hear that it was a genetic thing, which is far stronger than anything else? Did they testify to that?
No, and the reason for that is simply they're not qualified to.
So, okay, so now go back to that Dr. Mensch.
Dr. Mensch.
What did he do to relate this thing that exists, that nobody's contradicting exists, to behavior? He's a geneticist, so you're going to say, well, he couldn't do it. So did he do it or not do it?
Well, what Dr. Mensch testified to was that there are certain risk factors for people with XYY disorder, and that Mr. Tanzy and his background and his history are consistent with those risk factors. And that includes both physically and the behavioral manifestations, the mental illness issues that Mr. Tanzy has. These are all consistent with the XYY disorder. He wouldn't have testified, he did not testify that this caused behavior.
Okay, so isn't that then your problem? First of all, we're dealing with a crime that is, I mean, again, we are only dealing with crimes, death penalty crimes that are unbelievably terrible, but this one, you know, is sort of at the top of the tree that we were discussing last case. How, and again, this wasn't just an impulsive crime, this was over hours, this was, you know, rapes and taking. How does that then take anything that if the jury heard that this 12-0 verdict, which we don't see all that often at 12-0, would have just gone, oh my goodness, well, he's got that gene, and now we're going to just say this is overwhelming mitigation?
There are a couple of things in the question that you've asked. Yes, this is an extremely aggravated case. This is also an extremely mitigated case, I believe. And I base that not upon merely a history or a belief that he has a genetic disorder, or maybe he inherited a genetic disorder, which is not the case. Or, as the state argued at trial, that he chooses to have these behavioral problems, he's made these choices. This is a fundamental genetic issue with Mr. Tanzy. 1 out of 1,000 males have this disorder. If you think about it just in terms of how consistent his history is with the increased risks for this disorder, very clearly he manifests the signs and symptoms of this syndrome. Certainly, I would think a jury would be interested to know that. I would think the court would have been interested to know that had trial counsel presented it. I think if it were argued effectively at trial, it would go more to not merely he learned this behavior, this is nurture versus nature argument. All of these things were sort of thrown out to the jury at trial.
So if you take the judge's findings, which start at about this one, starts at page, or somewhere around paragraph 37, possesses, and he says at paragraph 40, he explains it, he said with men with this chromosome disorder tend to have diminished socialization skills, increased problems with intersocial skills, learning disabilities, and exhibit impulsive behavior. And then he goes on with it, and then he ends up saying it's not the violence gene, which you agree.
I agree.
And his history of antisocial behavior was extensively explored prior to trial, and then it's the jury chose to disregard his antisocial behavior. Is that the one, paragraph 49, where you go, if the jury has an objective reason for his behavior, they're going to give that antisocial personality disorder more of credence? Is that what you would say?
No. I think the jury viewed antisocial behavior as this court has viewed antisocial behavior or antisocial personality disorder as not being mitigating. And in the context that it was presented at the penalty phase, it's not mitigating.
Okay, but if you, I guess what I'm having trouble with, if we said, okay, we agree they really should have taken this ball that was handed to them and run with it and created a whole different case. And you would say that whole different case would be they wouldn't use the expert who altered his notes in Menendez, because why would you ever use an expert like that that's going to be discredited? And you wouldn't take two experts who are going to give inconsistent diagnosis. But left with it, then what are you going to do? What's the jury going to be presented with as to his mental illness, inability to control his impulses? What's the new picture going to be? And that's always the problem, I think, that you have in post-conviction. You've come up with some good arguments, better than a lot, but I'm still not sure that when the smoke clears, that what is the compelling mitigation that now is presented?
The reason that this is compelling, this XYY disorder, this is not some amorphous claim of a personality disorder that this person has some sort of personality problem. This is a genetic disorder. You can look under a microscope and see this. Trial counsel could have come in and put a picture up, as I showed a picture to Judge Garcia, that says, look, this is a normal chromosome, and it's an inartful term to say normal, but this is a normal chromosome pattern. This is Mr. Tanzy's pattern. You can see the picture. These types of things, jurors can grasp much more easily than some amorphous, it's diagnosis number so-and-so.
How does it go to say what you'd really have to show, that's, to me, that this crime was the subject of impulsive behavior, which somehow connotes a spur of the moment. And that's why I said I go back to the fact that he targeted this person, that he then took her. There's nothing impulsive about what he did when he forced her to have oral sex with him and then raped her and everything else. It's an ongoing, several-hour, horrible, but thought out, even to the extent that after he kills her, he doesn't go and buy drugs. He goes and, does buy some groceries and all of this. I just don't see how that chromosome changes the picture and the mental mitigation to an extent that it would undermine confidence, because that's where you have to get to.
I respectfully disagree with you on a couple of those points.
Okay.
I don't believe that this crime was especially well thought out, based upon the fact that it was done on a very impulsive basis. Certainly there were...
You don't think that, but what expert, see, you go back to this, I think so, you don't.
Right.
Then you need, I think that you needed one of those experts to then say, okay, now that I knew this, I would have, the way I would have evaluated this, everything now falls into place. Now that I know he had that chromosome disorder, I now understand everything that happened in his life, And now I'm going to explain to you how this crime is related to having this genetic predisposition.
If you're suggesting that that Mr. Tanzy needed to show that his trial experts changed their opinions based on this.
Not just that, but somebody did, other than that you have Dr. Mensch just giving sort of, these are predispositions. It would be like somebody just saying, well, now we found out he had brain damage, and then going, and brain damage can cause somebody to be impulsive, and we know that if it's, depending on what, if it's the temporal lobe or frontal lobe, or what are those lobes, and yet you then don't really put it all together.
Dr. Dudley, who's a psychiatrist, a medical doctor who has a limited training in genetics, was able to testify about the importance of the XYY diagnosis. But more specifically, we're not saying XYY caused him to do this, and we're not saying necessarily that XYY disorder caused him to be impulsive to the degree that he would commit such a crime or crimes. What we're saying is if you look at his developmental history, which was explored at the penalty phase, there are explanations. There are reasons other than just simply Michael Tanzy is an evil person.
But we do know that large numbers of people with this condition do not do things like this crime, but even the other sorts of things that might be considered socially unacceptable. There are people that have that particular condition who live normal, law-abiding lives, are perfectly functional. Isn't that correct?
That is correct. However, I think that view is selecting this one area of mitigation without exploring or considering all of the other areas. Yes, some mitigation was presented at the penalty phase, and I think it was rather compelling, but again, it didn't have, as Justice Quinn says, the puzzle, I think is, or excuse me, Periante said, it didn't complete the puzzle. And the puzzle is why does Michael Tanzy behave this way? What
But you just said a minute ago that it doesn't necessarily demonstrate that just because he has this genetic condition, that it doesn't necessarily mean that that was why he did this crime. So I'm still at a loss here as to what more would a jury, if the jury had heard he had this condition, but nothing else really about the testimony would have changed. I mean, we still would have had the doctor saying what he said about, antisocial personality disorder and all these other things. I'm just not sure where that gets us. What would a jury have done with that?
I think that a jury, again, antisocial personality disorder is not necessarily a very mitigating thing.
So if you hear that you have this personality disorder because you have an XYY chromosomal makeup, that's going to make the difference?
It contributes to the personality disorders that Mr. Tanzy shows. I'm sorry.
Is the XY-chromosome, is that a violent gene?
Absolutely not. There's the term, the violence gene or the criminal gene, has been debunked since the 60s and 70s. However, again, there is a statistical link to behavioral and developmental problems beginning in childhood. Those sorts of behavioral and developmental problems are the types of things that contribute to somebody later being diagnosed with a conduct disorder or antisocial personality disorder.
You have now exhausted all your time except for about 2 minutes.
Thank you. I'll reserve the rest of my time if I may.
Good morning. Scott Brown on behalf of the state of Florida. The problem for the appellant in this case, aside from the horrendous facts and the 6 aggravating factors, is that XYY was not shown below to be the violence gene or anything, for that matter, relating to the facts of this case.
Well, the way I see it is this. First of all, the defense lawyers, for whatever reason, this isn't a Brady violation. The state gave it over. Obviously, I mean, if I'm a defense lawyer trying to defend this horrendous crime, I'm going, wow, I got something I need to explore. Why didn't they explore it, first of all? Do we know? Did they got overwhelmed, or did they show it to someone and they said, no, this is no big deal?
Well, actually, part of the problem was it was certainly in the public defender file. Mr. Kuipers was the only trial defense counsel available during the post-conviction hearing. He didn't recall ever seeing the note. Ms. Russell, the additional public defender who was assigned to the case, was deceased at the time of the evidentiary hearing. So we don't know, quite frankly, what happened. It was in the file.
I mean, in a way, but we know none of the, nobody used it at trial.
Correct, Your Honor.
And I really would at least say this: if you had this, and you have these horrendous facts, you try to make something of it, just like Mr. Cwell's using now. I'd say, wow, that's certainly better than that old antisocial personality disorder. And impulse control and all of that, now you've got sexual abuse. And here's my problem, and I still think I come out with the same thing, but I just got to say it. I do not understand, first of all, how somebody would use an expert. They had 7 experts that they had hired that has been known to be discredited because he altered notes in one of the most well-known murder trials of the last century, the Menendez. You'd go, no, I'm not using that expert. That's going to destroy his credibility. You use them, and then you find out, well, he says bipolar disorder.
Correct.
Even though, and no other expert had, but so now they're trying to find something they can hang their hat on. Well, I'd rather hang my hat on XY disorder than bipolar from some guy that has known to have altered records. And then I put on someone else who can't diagnose them with that. And they say, well, we don't like our experts to confer. Well, you might not want them to confer, but you certainly want to tell them, well, Dr. So-and-so found bipolar. What do you think about this? So that you've got a consistent theory. So my concern is that maybe nothing will, with the 6 aggravators, and this type of crime, that will undermine confidence in this being a death penalty case every way you try it. But I do see that those combinations, that is, using an expert that is has perjured himself, has altered notes, not having a consistent theory of the mental state, and then not doing anything with the XYY stuff, which could have at least helped. It seems that there are some deficiencies. And so help me, it may not be prejudice, but it does seem like it is, even though they did a lot, and I agree they did a lot, but sometimes you can do a lot and forget that you need to do something very specific for the defendant, not just throw it all out there.
Your Honor, first of all, these were highly experienced defense attorneys in the public defender's office. Ms. Russell was the assistant public defender, Bill Kuipers, tremendous amount of trial experience. He was the go-to guy in that office. He recognized early on after the deposition that Dr. Vickery had a problem based on that case, but decided that he is the most compelling expert that he had. He was the only expert who found an Axis I major mental disorder, bipolar, and he had a slideshow, and he had what trial counsel thought to be the most effective presentation in this case. Another problem that trial counsel had was some of these experts that he had consulted with thought that Mr. Tanzy's prior Massachusetts murder of Caroline Holder was relevant to their opinion in this case. So he couldn't use Dr. Meyer. It's not like there was a wealth of experts, despite having consulted with 7, who were willing to come in and have favorable testimony in this case. And
of course, then we don't know whether they would have been helped by XYY because they didn't testify in this evidentiary hearing.
That's incorrect, Your Honor. One did, Dr. Raphael, who testified at trial on behalf of Mr. Tanzy, and he was a neuropsychologist, and his firm was retained to examine Mr. Tanzy, and he ran 25 different tests on Mr. Tanzy. He was called by the state to testify in post-conviction, and it was his opinion that XYY was completely irrelevant to anything, any of his opinions in this case.
So I appreciate
it's in the record.
So that's actually the opposite.
Exactly, Your Honor. It shouldn't have been mentioned.
It seems to me the state, is it true the state turned over this evidence about the XYY, a couple of days before the penalty phase.
I believe it was 3 or 4.
So when did the state actually get this information?
The same day it received that information, because it was an informal telephone call. There was no formal report generated that said Mr. Tanzy's XYY. It was the state's DNA expert. He said, oh, by the way, he's XYY. And the prosecutor in this case, Manny Madruga, goes, I don't know anything about it, but it sounds like I might need to turn it over to the defense. And he did, at that point.
Did the defense at any point ask the judge for any additional time so that they could do anything with this new information?
No, Your Honor. And the reason is pretty clear. If you look at this record, and Dr. Mensch, while he was a geneticist and he was a qualified medical doctor, he didn't have anything remotely compelling to say about either A, Mr. Tanzy, who we never examined. He didn't link Mr. Tanzy's conduct to XYY. And in fact, Dr. Mensch has had occasion during his 45-year career to counsel 5 expectant mothers, and the fathers, I presume, that have shown that their child will have XYY. And what does Dr. Mensch tell them? He tells them that in all likelihood, you're not going to know your child even has it. They will be perfectly normal. And that's the real problem for the defense in this case, aside from the horrendous facts, is that it was not shown that XYY was remotely compelling. In fact, Dr. Dudley mentioned it in his lengthy testimony during the post-conviction hearing. One sentence. Dr. Dudley said it could have contributed to Mr. Tanzy's early childhood difficulties.
Well, I think if there was different, I mean, the thing is, if it was turned over belatedly and you didn't have now Dr. Raphael saying it's not making a difference. I mean, when Dr. Mensch says, when I counsel genetically and they have this, does he tell them there ought to be anything else therapy-wise that they do, or they just, it's like they don't even worry about treating that person any differently?
No, I believe he said there was no need to worry. In all likelihood, you'll never know it. Now, what was established below
but
was...
if you started to have a child that acted out like this boy did, is there then specific treatment knowing you have this genetic disorder? I thought there was something about you do certain things because you now know that it may be because of a genetic predisposition that this child is exhibiting certain behaviors.
No, Your Honor, absolutely not. And what we don't know about Mr. Tanzy is his entire record was extensively explored. He had learning disorders.
I thought Dr. Mensch, and I have to go back to what the trial court found, said that men with this disorder are more at risk for certain types of behavior, including learning disabilities, impulse control. He didn't say that?
As impulse control as a child.
That's what
yes, and he had those issues.
If they know it, then that starts to happen. Do they just not do anything differently because they're now exhibiting as a result of a genetic disorder?
I will say this about Dr. Mensch. He indicated that, and he agreed that it's not the criminal gene. He said that you could have certain childhood difficulties, but he didn't link those particular difficulties that Mr. Tanzy had to any particular genetic disorder.
In paragraph 45, the trial judge made a finding that this XYY gene is not some type of syndrome as generally understood by psychiatrists and psychologists.
Correct.
So if there's no syndrome, there would be apparently no treatment for it, right?
Well, and that's part of the problem for the defense in this case, is that you're exactly right, Your Honor. There's not a particular course of treatment. It's not recognized in the DSM-4TR as a genetic disorder affecting behavior. And again, the only expert who testified at trial, Dr. Raphael, said, I don't think it should even be mentioned. It's like being left-handed. Some studies show left-handed people are somewhat more statistically prone to commit crimes.
Well, what's in the record to support the trial court's finding on that issue, that there's no syndrome recognized generally?
The cross-examination of Dr. Mensch, he could not, during the evidentiary hearing, mention a particular syndrome supported by literature. Now, I know post-conviction counsel has found some support, evidently, that it's recognized as an aberration, but there are no commonly associated behaviors with this 47 XYY. So again, you have something so inconsequential that should it have been mentioned below? Perhaps. But again, this is a case with 6 aggravating factors, including HAC, CCP, where Mr. Tanzy's childhood difficulties were extensively explored, favorable mental health testimony was presented. Mr. Tanzy this was no bare bones presentation of mitigation. This was everything in Mr. Tanzy's background, good, bad, and ugly, trial counsel developed, except for that prior murder that happened 8 months prior to Mr. Tanzy abducting, sexually assaulting, and murdering Janet Acosta. He murdered Caroline Holder.
That wasn't, you didn't try to introduce that as a prior violent felony, did you?
No, Your Honor, that was a charge. He had been charged but not convicted, and he confessed to that as well. But again, during the post-conviction hearing, they present Dr. Dudley, who had an entirely inconsistent diagnosis with every other expert in this case. Now, Mr. Tanzy has borderline personality disorder. So they want to really cherry pick some of the favorable information that might have come out on XYY while ignoring the elephant in the room, that prior murder, which was introduced during the evidentiary hearing below. And the facts of that murder are absolutely horrendous, and they're similar to the facts of this case. I mean, he selected an isolated female victim. He beat her on the head with a stick. He strangled her. When she wasn't dying quick enough, he stabbed her in the neck with scissors, and he sat on her until she bled out. So when you balance whatever positive they have on XYY against the tremendous negative information, which was properly introduced and considered by the court during the post-conviction hearing, there is no doubt that counsel has not carried his burden of establishing prejudice. And again, the state does not concede any deficiency on the part of trial counsel in this case. There are no further questions?
How is the genetic scenario as played out in the presence of a jury different than presentation of military background as analyzed by the court in Porter, and looking at those broad general statements that the jury is supposed to have all aspects to consider, everything about a defendant? How would you address that?
Well, Your Honor, if the Porter is a very unique case on the facts of significant combat experience during the Korean War.
I understand exactly what they were, and that those were factors, but again, those are the broad general statements that come out of Porter.
Well, I think first of all, you're most likely never going to know the genetic component. That's what Dr. Raphael said. I've examined thousands of people, and it's just happenstance that we know he's XYY. Well, does that make any difference in this case? So you have to analyze the mitigating weight of that, and the defense did not establish that it was significantly mitigating, I would submit, at all, because more likely than not, if you have XYY, you're going to be perfectly normal. No one will know you have it. Most people with XYY don't know they have it.
Well, but when you look at Porter, my former partner before I came on the court was exposed to just unbelievable wartime conditions in Korea, and his feet were frozen, and he didn't kill anybody. And that is that you say that the court has said that in the Porter context, you need to present those kinds of things to the jury. I mean, in Porter, this court, I think, held that it was non-prejudicial, but was overturned on the theory that, as I understood it, that those kinds of things do undermine the confidence in what's happened in a case, because they are significant enough. So that's what I'm asking here. How is do you perceive you're saying, genetics may or may not apply. Well, the same thing applies to war heroes. May or may not kill somebody.
Well, regardless of whether it may or may not apply, the combat experience and the travails that one experiences serving their country is completely different from having an extra Y chromosome, which more people are perfectly normal than not with it, and there's no link to violence or anything that occurred in this case. So I think you're trying to...
I thought even you said that there are risk factors.
Exactly.
And some people may and some may not, but it's a risk factor.
Correct. Just like having a poor childhood, being sexually abused, having ADHD, and all of which were explored and presented on behalf of Mr. Tanzy at the time of the penalty phase.
You know, I guess it's like this. I would say, and Porter, we could look back at Porter, I think, as to whether the Supreme Court was right, but they're right because they're the last. But here, my concern is, and maybe it just goes back to, I'm a defense lawyer, and I'm dealing with a horrendous case. I find out I have this genetic disorder. I explore it, and there's probably not a downside in me presenting it and trying to develop. But I think that that what you've really pointed out, now I see where it was, is the state called Dr. Raphael, who said it wouldn't have made a difference in his testimony. So that in this is that whether it was deficient not to explore it, just like you wouldn't ignore military record or whatever. In this case, it doesn't add up to undermine confidence. And that would be really, to me, rather than saying XYY isn't mitigating, because I don't know that we know enough to say it's not mitigating. I'd say that I would have, if I were a defense lawyer, I'd grab onto it to try to put something in context along with the sexual abuse, the father dying, the whole, everything together.
Well, you might latch onto it unless you're expert, like Dr. Raphael said, it's irrelevant.
I mean, again, you can't go after and say, well, why didn't you do it? They didn't do it because either it was presented too late and they just put it in the file, but it wasn't like they explored it and decided not to present it.
And that's the silence of the record is we lost one of the defense attorneys. So we don't know what, if anything, Ms. Russell did with it. She could have called Dr. Vickery for all we know.
From the state that says someone has a genetic disorder.
Well,
and you don't know what you explore it. I don't think we could really say that if they didn't explore it, that would be acceptable.
It's not we never agreed that it was a genetic disorder, and to this day, it's not a disorder because people with XYY, it's not Down syndrome. You're perfectly normal in all likelihood.
It's a genetic, what would we say? It's
a genotype. It's a different genotype, and that's it. And I would dispute the notion that there's any generally recognized behavior associated with having 47XY. It's like being left-handed, perhaps.
There's increased risk of these following
childhood difficulties, and he had those. And again, given the overwhelming weight of aggravation in this case and revelation of a prior murder and those gruesome details, there is not the slightest possibility of a different outcome at the time of trial if counsel had only discovered and presented evidence of XYY. We ask that you affirm the order of the post-conviction court below. Thank you.
I know I'm really short on time, but I do need to respectfully correct Mr. Brown. The state did not call Dr. Raphael. The defense called Dr. Raphael. Dr. Raphael is a psychologist with no training or expertise in genetics. Dr. Raphael testified for the
Mayfield?
He pronounces it Raphael. It's okay. Like Raphael, but Raphael.
I was trying to determine we're talking about two different people.
Sure. He was...
At what point? At the penalty phase or the
No, at the post-conviction evidentiary hearing. As a matter of fact, we went to great lengths to call Dr. Raphael because he wouldn't appear in person. We put him on the phone. I noticed that in the brief. I thought it was a typo, but apparently the state is mistaken, and that happens. My concern is that this court is going to put any credence in Dr. Raphael's testimony about genetics when he testified at the evidentiary hearing that his only experience with this disorder is that he had researched it on the internet, done a Google search or something of that nature. I don't want to misstate the facts.
What was his purpose at the evidentiary hearing?
His purpose was to present the fact that he was never presented with this fact. And
then you weren't able to get the opinion out of him that may have done something here. I mean, I'm sure we don't have to, but I am sure that you searched for somebody that would have taken this and put it into the kind of package that would have made it really compelling. And it's absent in this record that there's anything other than it's a genetic type. I mean, that is an increased risk factor, and nobody connects it up.
Again, I have to respectfully disagree with you. It is most definitely a disorder. 1 out of 1,000
Well, again,
is
you
a...
don't have to, as Mr. Brown has said, it wasn't a disorder.
Okay,
so I'm not-
1 out of 1,000 is, I think, a disorder. It's an abnormal genotype. There are physical and psychological manifestations of it. There's one other thing that I needed to correct. Mr. Brown is relying, as he did at the evidentiary hearing, extensively on this uncharged, or excuse me, charged but unproven prior murder. That evidence would have never come in before a jury, and had the state tried to put it in before a jury, there would have been an issue at the trial. There was a motion in limine, it was successful, all of that would have been excluded. Now, Mr. Brown
Has
is...
he since been convicted of that crime?
No, not to my knowledge. He has not been convicted of it. There hasn't been a trial or anything of that nature.
You could sum up 30 seconds.
My sum up is that I would ask that you reverse the trial court's order and remand for an additional evidentiary hearing, or reverse for a new penalty phase. Thank you.
All right, we thank you both for your arguments. The court will now stand in recess for 10 minutes.
All rise. All rise. Supreme Court of Florida is now in session. Please be seated.
We now take up the third case on our docket, Kaminsky versus the state of Florida.
Good morning. May it please the court, my name is Gary Caldwell. I'm an assistant public defender. I'm here on behalf of the appellant in this case. I have a lot of issues in the brief. Obviously, I won't be able to discuss them all, so I would like to, time permitting, address the first two issues, which have to do with the state's main witness, Deborah Thomas. Also, the seventh issue, which has to do with another witness named Joan Cox. And if I have time, I would like to discuss issue number 5, which pertains to the treatment of circumstantial evidence, instruction, and argument at the trial. The state's main witness in the case was this Deborah Thomas. She supplied 4 important circumstances in support of the state's case. She said that the defendant was bloody on the day of the crime. She said that he gave her a ring which matched the victim's ring.
Did the defendant basically agree that there was blood on him that day, that he had cut him, had been in a fight with someone, and that's why there might have been some blood?
Well, that was her story, right, that he had said that, right.
And the defendant did not agree that he had been in a fight that day?
Right, right. She also said that after he spoke with the police, he came and he got this ring and disposed of it. And she also said that he was the person who owned this Jeffrey Bean bag that the jewelry was later found in. So those are 4 very vital circumstantial facts on which the state rested, and all 4 of them came from her. Now the state had to build her up as a witness at the same time, of course, that it was trying to tear down the defendant. And it did this by having this long, involved testimony about the course of their relationship over many months, over a year. And included in this was testimony that she had gone to Arizona, she came back, she had another boyfriend on the side, she was married to someone else. And that she came back to him because he made threats against her life, the life of her new boyfriend or her other boyfriend, and her family.
Did you say she was gone for a year?
Excuse me?
Did you say she was gone for a year?
No, she was. No, I didn't say that. I said this. They testified to this thing over the course of a year. She testified to. Okay. She goes to Arizona for a few months or a month. She comes back. She goes back to Arizona. She goes to Daytona Beach, I think. I forget exactly. She meets the new boyfriend. She moves in with the new boyfriend at this place where the jewelry was later found. And so it's this long, involved thing that goes over the course of a year or more.
Now, is it, in terms of putting that on, the course of their relationship, the only motivation for, well, in this case, the motivation was he wanted to do anything to try to keep Deborah Thomas as his girlfriend and marry him. So everything that was occurring during that time was showing what lengths he was going to try to have her back, and eventually then the crime. So your argument on this first point is that the testimony that he threatened her and that's why she came back should not have come in?
That's correct. I'm arguing that should not have come in.
Now, the judge did leave out or excluded the testimony about the domestic violence and that she ended up with a broken arm.
Well, we don't know what the facts are of
Well, was that
that.
excluded? Was there some things about their relationship that the judge actually did exclude?
There was some agreement, which doesn't appear in the record, that there was not going to be testimony about some incident about which we know nothing other than that there's something about some act of
Okay, so the
domestic
judge-
violence or not. We just don't know.
Was this, the testimony about the threats subject to the motion in limine?
No. No,
It
the
was just
defense thought it
objected
wasn't going to come in. That's
Excuse
what
me?
the defense attorney said. I didn't think this was going to come in because I thought we had an agreement there wasn't going to be evidence of domestic violence.
And so so did the attorney then object when it was, when she testified to it?
Yes.
Was it the same testimony that she testified to in the first trial?
Yes.
So why would he think it wasn't going to come in?
Because apparently they had this discussion off the record that the state had said it wasn't going. The state didn't dispute that there had been an agreement not to introduce evidence of domestic violence.
So what was the actual testimony that you think should have been excluded?
That she moved back in with him because he threatened her, the new boyfriend, and her family.
And how did he threaten them?
That was the
But the
testimony.
idea was it was an
It threatened
implication.
their lives, I believe.
So he said, the testimony she said is that I moved back in because he threatened their lives?
I can read you the exact testimony. Because he threatened me, and then there was the objection, and then she said, I didn't want anyone to get hurt because he threatened me and my family and Ben. Didn't want them to get hurt. I mean, didn't specifically say threaten their lives. Didn't want them to get hurt.
And the objection was what?
It was
What did he-
irrelevant, that it was improper Williams rule evidence, that there was not notice given to the defense that the state was going to present this evidence.
Later on, when the police actually came to speak with Ms. Thomas, to question about the ring, and she basically lied to them and told them that that's the same ring that he had given her before in previous engagements. Later on, she testified that she lied, and the reason she lied is because she was afraid of him, or he may have threatened her.
No.
What was the reason that she gave?
She said I panicked and I didn't want to be implicated. That was on direct examination. That's at page 2,823. And on cross-examination, in almost exactly the same terms, at page 2,871, she said, I panicked and I was afraid that I would be implicated. And she also said, I panicked because, I forget the exact words, I didn't want to be implicated. She did not say that she lied to the police because of this threat. This threat was not tied to that. She said it was because she...
I'm not talking about the first threat to Parker into moving in with him. I'm talking about, did she not say that one of the reasons she lied was because she was afraid of him because of his previous threats and that type of thing?
I'm not following. When she was asked why she lied to the police, she said she didn't want to be, she panicked and she didn't want to be implicated.
That's the only reason she gave for lying.
That's the reason she gave, right.
You didn't say anything like she didn't tell the truth because she was afraid? Afraid.
Well, she said she panicked. And that, I mean, she didn't say it was because he had threatened the family. Or the boyfriend. But the point I'm trying to make is that this makes her into a collateral victim of the defendant, and it attacked the defendant's character. And the state says that it's necessary to prove the motive, but it's only that's why it was admitted, was supposedly to prove a motive for the murder. That's what the judge's ruling was, that it was inextricably intertwined, that it went to the motive of the crime. But it's really just a motive for a motive. What it is that the motive is to kill her to get the ring. The motive to get the ring is to keep her. So then the motive for the motive is that he got her back.
If we would agree
Mm-hmm.
that there was something improper about the admission of the testimony concerning why she moved back from Arizona and friends, where does that get you in this case? I mean, it seems to me that any admission of that would be harmless.
Well, nobody likes a bully, and that's what this is. No, nobody likes a bully. That's what she's making him out to be, is this bully who's threatening her. She doesn't want herself to be hurt. She doesn't want her family to be hurt. She doesn't want the other boyfriend to be hurt. And the state argues this the state argued to the jury that went to what Justice LaVarga had mentioned about the reason for her what she said to the police, but that wasn't why the state was admitting it. The state was admitting it for this purpose of showing this motive for the motive for the motive.
Honestly, maybe Ms. Campbell can tell us, how him threatening her is a motive for the murder of the victim? I thought, and again, what I asked you earlier is that this whole idea of what was happening over a year is that he was desperate to get her back. And was using any means. So one was he threatened her. The other was finally he was going to have to get her the things she wanted, a diamond ring, a house on the beach, all of these things, because he would go to any extent to have her stay with him. I mean, isn't that how if it's relevant at all, isn't that how it's relevant?
Well, that's the state's contention, right?
Okay, well, that's different than it's a motive for the crime. It explains his behavior about why somebody who is 50 years old or 49, that's never killed anyone in their whole life, who works in a somewhat respectable industry, presumably, would target somebody and kill her so he could get a diamond ring, that he was that desperate to hold on to Deborah Thomas. It's the only way to explain is what lengths he went to keep her as his girlfriend and his wife.
Right.
So you would say, yeah, but that's still prejudicial. It's really not. It's marginally relevant, and the prejudice would outweigh any probative value because it still is a threat, which is a bad act, and that would lead you to your second point was if you're going to let it in, then let us cross-examine her on the fact she really moved back in because she was on drugs and she wanted more drugs.
Right. Well, certainly once this comes in under Cwell, we're entitled to cross-examine on that. There's no doubt about that. I submit. My friend might disagree. I submit that we have an absolute right to cross-examine on that.
And I could see, let's take that there may be two errors, that is the threats and this other thing. This case, I don't know whether the state put more evidence in or stronger or used it in a stronger manner, and I know you attacked the cell phone records, but he doesn't just show, she's not the only witness, she being Deborah Thomas. He shows this ring to his coworker, and she identifies the ring as the ring that the victim owned. He was the last one. No, she didn't.
Coworker?
Oh, I thought more than Deborah Thomas identified the ring.
Okay, the coworkers did not identify.
Okay,
Did
who
not
else
identify
identified the ring?
There's Deborah Thomas's friend, and again, we contend we were not allowed to properly cross-examine her, but there was the friend who later on saw Deborah Thomas with this ring, and she says it's the same ring. But Deborah Thomas is the only person who connects this ring, which is identified as being like the victim's ring, and connects that to the defendant, puts that ring in the
There's no
defendant's
evidence
hand.
from that co-workers saw a ring?
A ring, yes, sir.
Okay, so there's a distinction that you're making, that they did see about this time that he had a ring, and it was for the Miss Thomas, but they just didn't connect it. Not that they said that's not the ring, it's just they weren't presented as witnesses to identify which ring it was.
Well, one of them, I think, said that none of the rings in this ring lineup that has this replica ring look like the ring, and the other one also did not identify it. And they both, they didn't spend a lot of time staring at it, but they looked at it, and they said that it was not like.
Is that evidence coming in that was not the ring?
They didn't say one way or the other.
Okay,
I think,
so they did not identify the ring then?
Right.
Okay.
But in point of time, it was how long after the murder did he show the people at work this ring that he now had, and he had it in a tissue?
It's a few hours, right.
So it's, that's a pretty strong circumstance. The cell phone records are a pretty strong circumstance, and, I think they come in, but they don't come in, that's obviously an issue. The fact that he calls in sick that morning, says he's going to, or is going to meetings. The circumstances seem overwhelming.
Well, I disagree with that.
And I realize that overwhelming evidence isn't enough for harmless error.
Right.
But just trying to, again, put that in perspective as to whether the threat was not necessary, for the state's case.
Well, each of these things that you mentioned are you're building inference upon inference upon inference. The cell phone
Well, there's separate inferences. When you say building,
right.
Each piece is separate. Seeing a ring hours after is one circumstance. Calling in sick and then not really being sick is another circumstance.
Well, he didn't call in sick, but
Well, he didn't come to work.
well, right, but that had
But
been
what
his.
I'm saying is they're not building on it. They're creating a matrix of facts that are not one inference upon inference. They're separate facts.
Well, there's suspicious circumstances, but again, each one in itself involves inferences to reach that circumstance. Other ones involve circumstances to reach this circumstance. Others involve inferences to reach this circumstance. Each of the circumstances are developed by inferences.
You just pretty much define a circumstantial evidence case. You
Well,
take each piece and you put them together, and that's. Well, let me take you back to the ring.
Okay.
The two employees that he talked to, I believe, was Deborah Flynn and Nicole Rizzolo.
Rizzolo, I guess that's how you pronounce it.
This is a very long record, and maybe I'm a little confused, but wasn't there like a ring lineup that they showed a similar ring in a catalog? Didn't they show that to these two folks?
They did.
The police did?
They did.
And didn't one identify the ring in the catalog as being the same as they had seen when he showed it to them?
No.
I thought that one of them picked him up. Maybe I'm wrong. That's why I'm asking.
Like you, I have problems with these huge records, but Rizzolo picked out the replica ring was ring number 3 in the lineup. Ms. Rizzolo picked up ring number 4, looked at it, and she didn't say this is the ring or anything like that. And she put it down, and she said she didn't pick out this ring number 3 and say that's the ring. Flynn also said that none of them was. She didn't identify any of them as the ring.
But Deborah, the other Deborah.
Deborah Thomas.
Last name.
Peltier?
Not Deborah Thomas.
The Peltier?
There's a bunch of Deborahs.
Deborah?
There's
that was her, okay.
Deborah Flynn is the co-worker, the defendant's boss. Deborah Thomas is the state's main witness. Deborah Pelletier, that's how we pronounce it in Louisiana, Pelletier, was this woman who was married to this Ben Thomas fellow.
Didn't she pick the ring out?
No.
Who did in fact pick the ring?
Okay, right, it's right, it's a mess. Okay, Deborah Thomas picks it out. Deborah Thomas's friend picks it out. Maureen Reap, right. Maureen Reap, who,
two people.
right. The police officers who see this ring on Deborah Thomas's finger identify the ring. I believe those were and there was also another woman who had several dealings with Deborah Thomas involving the lease of the property, and she does not identify the ring. She's shown the ring lineup. This fellow Ben Thomas, I think he was shown the ring lineup. I'm not 100% on that, but in any event, he didn't identify it. He didn't identify the ring. So in any event, okay, my issue number one, which was that we submit, was this evidence that simply built her up as a witness, as a collateral victim of the defendant, and attacked the defendant's character was not admissible. And that, okay, number two, if the state gets to go into all of this stuff, the defense gets to go into it too, as to why she's kicked out, why she comes back, and all of that. I mean, and the situation here is pretty much like in Cwell, in which this case reversed a first-degree murder conviction, where Mr. Cwell is charged with murder. The murder was committed by this other person who was the state's main witness. This other fellow says that he and Cwell discussed murdering Cwell's wife on many occasions, and that they did not follow through with the plans. So on cross-examination, the defense asks, well, did you kill Mrs. Cwell pursuant to these discussions with the defendant? And the court will not allow the cross-examination on the ground that it was not covered in direct examination. There was no proffer in that case. On appeal, Cwell argues that this went directly to issues which were explored on direct examination, and they would be used to set up a defense that the defendant's other girlfriend was the person who caused the murder to be.
Counsel, you had indicated you wanted to reserve 10 minutes. You're now into your
all
rebuttal
right,
time.
okay.
You've
Well,
got still 8 minutes
I'll reserve my time for rebuttal. Thank you, sir.
May it please the court, good morning. I'm Leslie Campbell. I'm with the Attorney General's office on behalf of the state. With respect to the motivation, Your Honor, Justice Periante, you summed it up as the state would sum it up. It does go to the overall motivation of the defendant to get and keep Deborah Thomas.
The problem I have with it, I guess, is that it marginally might, but the idea that there were threats is really coming out of course, her mouth. Got a motive. She might have been charged as an accessory. And it's about threatening not only her, but others. So it's really painting him as sort of a thug. So it is character evidence. So whether it's marginally relevant, but it would seem the prejudicial value would outweigh it. And then if the state is trying to say why she moved back in because he was a bully or a thug, it seems to me that it would be proper to cross-examine her on, you're a drug addict, you use drugs, and that's why you moved back in. I don't get allowing it necessarily, but then I don't get that if you allow it, why you don't allow that cross-examination.
Well, that's assuming that the threats are merely to smear the defendant.
No, I know you say why it is, but I'm saying it has that effect.
I understand what Your Honor is saying, but the drug aspects a tit for tat would not be proper.
But if they're arguing why she would move back in, okay, she says she moves back in, not because she now loves this guy, but because he's threatened. He says, no, I have, and my testimony has established it, I have a good faith basis to ask her, you have had drug problems, and didn't you move back in because you had a drug issue? It seems that it's not tit for tat, but it goes to her motive, why she's saying why she moved back in. Why don't they have a right to question you moved back in because you were fired from your job? Just let's say that was the reason. They can't ask something they have a good faith base. You moved back in because you had a fight with your mother. You moved back in because you were evicted from your place. All of those would be appropriate to say you didn't move back in because he threatened you. You had another reason, a financial reason.
She moved back in for several other reasons other than the threat.
Well, you don't know. First of all, it's all in her mind as to why she moved back in.
Right.
She's saying, this is why I moved in. They have a right to cross-examine her about that you didn't really move back in for that reason. I have an objective reason that you moved back in. I don't understand how that doesn't come in.
Under the case law, the fact that she's a drug addict could come in for three reasons. One, that she was taking drugs at the time that she's perceiving these events, and therefore she cannot perceive them properly. She takes drugs to such a degree that she cannot report what she's seen. And the third fact is she's on drugs as she's testifying.
Can I ask you this? I didn't think the evidence was that she's a drug addict. I thought they wanted to cross-examine about that she moved back in because she was having drug issues as a motivation to counter what she says was the reason she moved in. And I'll look back at that.
I didn't read it that way, Your Honor.
But I thought there was some question about him wanting to put on evidence about her drug use, and that's why we have this on again, off again, she's going there, coming back. But all of that was a part of her ongoing alcohol and drug problems, and that he would throw her out and she would go away and then she would come back in. I mean, it seems to me, as Justice Periente was just saying, that all of that would in fact be relevant and it would be proper cross-examination if she's saying, I did this for one reason, and he questioned her, wasn't there other motives, or this was really your motive for coming and going?
The defendant's testimony from the first trial was played for the jury, and that testimony did come out, that he claimed that she was a drug addict, that she liked certain prescription drugs, and that they had this ongoing...
But her acknowledgement of that is a different thing. If she had in fact been questioned about it, and she acknowledged she had a drug problem, that was part of the reason they had this on again, off again, she's going there, coming back. That's a different thing from him saying it, and her acknowledging it, isn't it?
And the trial court felt that it was not relevant because it didn't go to one of those three areas.
But the defense responded. The state had opened the door through Deborah's testimony that she came back to the defendant because he threatened her. The defense asserted it should be able to rebut the threat testimony by showing it had nothing to do with threats, but rather his tolerance for someone who was an alcohol and drug abuser. So it wasn't like the defendant didn't alert the trial judge that that's why it was coming in.
And the trial, and before the jury also was the fact that this same person who's claiming he took her back because she's on drugs, or he threw her out because she's on drugs, also was plying her with gifts and flowers and promises of a.
Well, that goes to whether once you cross-examine, whether that would have destroyed her credibility. That's a different story than whether it should have been permitted. I mean, we try in these cases to try to go, let's make sure we get the rule of law right, and then we go to whether it would have made a difference. So you're going to, it wouldn't have made a difference, the jury wouldn't have accepted it.
I'm saying it's everything, Your Honor. I don't believe that that was admissible evidence based on the case law, because it didn't go to those 3 areas where drug testimony is, or drug abuse is normally admitted. And
we're not going to get any place with that.
I want to, but can we go, I'd like to just go to something I had asked about CCP in the other case. This is the case where there was a special interrogatory verdict, right, where the jury found both premeditated and felony murder.
Yes, Your Honor.
Okay. On CCP, the last case you were here for, the last case, you know, where the only reason somebody would have taken someone out to the cemetery and done all those things was to kill her. Here, why is it that evidence establishes that he went to the victim's house with the intent to kill her as well as take her ring, as opposed to he went there in order to rob her, and then based on her refusal to give it up or whatever, he then ends up killing her? How is the CCP, let's just take things leading up to him getting to the house. What evidence is it that he came with a prearranged plan to kill her?
We have him setting up his alibi to begin with, that he's going to life care instead of going directly to see his boss's boss. And there was testimony that he might have been up for the administrative job. But he decides to forego that meeting to go to the victim's home. We have him making phone calls before that in a very calm manner. There's nobody's seeing any anxiety in him. He has been to the home before. He knows that all of the windows are shuttered, except for the front window. He knows the victim. He has dealt with her for 2 weeks now, and he has had to move furniture for her.
And he also knows she always wears the ring.
And
right?
she wears all of her jewelry all of the time. What he also knows is that she seems a little disabled because he has to move the furniture for her, move the suitcase for her. The minute he gets in the house, while he did not bring a weapon, and that might be a problem, he armed himself with what was available, and this court has allowed CCP to go forward where someone goes to a home and arms themselves with a weapon that's in the house.
I mean, again, I know we have that. I think we have to be careful, but I think probably the best point is that she knows him.
Absolutely, Your Honor.
If he wanted to set something up where he was going to rob her and not kill her,
he might do it at night.
At night, maybe with a mask or something else, so she wouldn't recognize him.
He attacks her immediately in the foyer. There's blood evidence in the foyer. Her glasses are nearby. And then he possibly stabs her with a broken piece.
So there's no indication that he would have thought she wasn't home and left her ring there.
That's correct. He's always seen her with all of her jewelry, and the testimony is that she wears all of her jewelry all of the time.
Did he know she was going to be there that morning?
He knew that she was leaving that day. So
how did he know she was leaving that day? I mean, I've seen that said in these briefs, but how did he know that day? If I understand the record, he said that she was going to be leaving.
the family was coming down, and they were supposedly leaving the next day.
There was a knock on the door. She was on the phone.
Yes. You could not see who was at the front door because of where the windows were placed and where the shutters were down. So she opens the door and she is attacked at that point.
Where does he, but you say there's not an indication that he brought the weapon with him. How does he attack, what does he attack her with?
With the ashtray, with the standing ashtray.
So it's something he might have known was there?
Was there. He had been in the home. So he had
I mean,
moved.
you would have thought, but of course this is, that he would have brought a weapon with him if he was
Maybe he did bring a knife. The testimony is that some of the wounds are consistent with, could be a knife or some other sharp forced instrument. He also, after this attack in the foyer area, he drags her to a back bedroom where an additional attacks take place. She loses 4 teeth, and then at one point, and she's dragged on her back.
Well, again, I would say that if there was some evidence that he came there only to rob her and then it sort of escalated, it may be different. But I'm accepting that these facts really show that he only would have been going there with the idea that he'd have to kill her as well as rob her.
At 9 o'clock in the morning, you're probably awake.
I think that's probably those are all circumstances that I think support that. But I just wanted to make, I had a little concern about it, but I think you've.
And then as far as the HAC, because there may be some concern there, there was a defensive wound on her hand.
It's hard to not see this as HAC.
Yes, Your Honor. With regard to the Joan Cox, if the court wishes to get into that.
Well, there was that she should have been allowed to be impeached. Is that his argument on her?
No, not with Joan Cox. Joan Cox was the other woman who had been trying to place her mother, I believe it was.
Before we get to her, you know, we've talked about Deborah Thomas a lot, but I thought there was also an issue raised about Deborah Thomas concerning the admission of testimony that he had intercepted her mail or something. I mean, you know, because in my estimation, Deborah Thomas really is a very important witness in this case. And so it's real important in my mind that we look at these issues about the admission of certain parts of Deborah Thomas's testimony. So what was the purpose of the testimony that was admitted concerning whether the mail being intercepted by the defendant?
It again goes to the desire for this defendant to have absolute control of Deborah Thomas and to keep her with him. She had moved for, I believe it was a 2-week period, to see her daughter out in Arizona and to get her nursing license out in Arizona. However, she didn't change her address. Her nursing license for Arizona was still with the Florida address. And she had been in the home with the defendant alone, and he then was there alone. So the only person who could have taken her mail, accepted her mail and taken her mail, and not given it to her when she returned was the defendant. So it goes to, again, his overall motivation and, you know.
Well, there is some issue concerning the defendant wanting to put on another reason why she did not get her license that had nothing to do with whether she received her mail or not, and the defendant not being allowed to put that evidence in. So there was some issue about she couldn't get her license because of her.
I don't remember that argument being made. I do remember the argument that you know, that she just couldn't get she didn't get her nursing license because she didn't respond in time.
We're going to talk about Ms. Cox.
Yeah, Ms. Cox, well, that was just the next issue that Mr. Caldwell was going to talk about. I don't know if he's going to get into that, but just a quick answer on Ms. Cox. She was another person who was trying to place her mother in Lyford Cove, and the defendant's argument is that he doesn't recognize jewelry, he doesn't look at the jewelry, it doesn't enter or factor into his decision, and yet we have another person where Mr. Kaminsky has recognized that someone has expensive and a nice piece of jewelry. There was one other issue with regard to Deborah Thomas and where she was staying with Ben Thomas. For just, I think, a 3-4 day period, they were in the Thomas Pelletier home in Port St. Lucie. However, for most of the time, she was staying with Ben Thomas in Vero Beach.
Now, Deborah, they were, this was at that point an affair. He was married to who?
Deborah Pelletier.
And
There-
so
there's
when they
several
were
Debras.
living together, he was going to leave his
They
wife
were going
for
through a
her.
divorce, yes.
Okay.
And with respect to the shed that's on that property, the door to the shed, it's a wooded area, it faces away from the house. The defendant had been to that house 2-3 times a week during the summer, discussing Deborah Thomas's affair with Ben Thomas and keeping Deborah Pelletier up to date on this. And so he had been to that shed, he had actually done some work for her, helped her when something had gone wrong, and he passed by, based on the cell phone records, he was in the area of that shed on the day of the murder. And as the court will recall, the jewelry was found in that shed, up in the rafters and behind some tar paper. It wasn't easy to find. It wasn't just thrown in there.
Was it, part of the jury was a tennis bracelet.
Excuse me?
Was that jewelry identified?
What was identified?
The jewelry that was found in the pouch?
Yes, it was identified. In fact, also the defendant had noted that he had, at the same time that he had gotten this ring, he had noted that he had also gotten a diamond and emerald tennis bracelet, although he did not show it to his coworkers. And what's significant about that is that it was a diamond and emerald, and also the coworkers saw, while they didn't identify the ring exactly, they certainly identified it as a 2-carat, a large diamond ring. And this is just 2-3 hours after the state's estimation of when the murder took place.
They showed a couple of pictures of the ring, and did one of the pictures have her with her grandchildren?
Yes.
Wouldn't it have been better to, because that was in the guilt phase, right?
Yes.
Wouldn't it have been better to show those pictures without having the grandchildren?
I don't believe there was a way of cutting the grandchildren out and still showing all of the jewelry.
Well, you would agree if there was one that would be a better thing to do.
Well, it certainly would have
I have a
reduced an issue on appeal.
see a photograph. Maybe I'm confused, but one, number 109, he says it's admitted without objection. It shows her standing up, and I take it that's the ring?
Well, but the other one showed other pieces of jewelry.
Okay.
Not all of the jewelry was on that one photo.
The ring could have been identified through this photograph.
Well, one of the rings, but I don't, but not the other jewelry. There are other pieces.
So this one here with the children.
Yes.
That one demonstrated what showed what a lot of jewelry.
I think it's this, right, and it's a better representation of that jewelry.
Was the tennis bracelet there?
Your Honor,
You can't see it. I can't see it. Don't worry about that.
Okay.
She has a lot
And
of
black and
jewelry.
white might not be as clear as a color photo.
I'm just wondering, in looking at this photograph, which is 110, which is admitted over objection, it seems that she has a lot of jewelry on, and I'm just wondering if any of the ones that were found in the pouch in the house was connected to this photograph.
Well, all of the jewelry was identified as hers, and I do not recall if they actually said, well, this piece is this piece. But the family members did identify everything. However, I do believe the diamond and emerald bracelet had been lost by the time of this trial, of this latest trial.
And the actual ring
Has never been found.
was thrown on the beach somewhere?
It was thrown away. He came home after his first interview with the police, and Deborah Thomas had already taken the ring off, and he picked up the ring, put on his swim trunks, and left for about 20 minutes. The ring has never been found. So,
What was the defense theory of where the ring came from?
that either she had purchased it or he had purchased it. It was
there any evidence
$4,000.
that was supported that alternative source?
No. Other than the defendant's testimony, no.
What is-
And that ring was never produced.
Can we just go over the mitigation here? It's a guy, 49, working, again, never committed a crime in his, at least a violent crime. I don't know if it was any crime, but.
He did commit some check crimes.
Okay. And he becomes so obsessed with this woman that he's going to do anything, including killing somebody in a brutal way. What was the mitigation to explain that behavior?
Well, he has maintained his innocence, so there was no evidence of any mental, extreme mental or emotional disturbance or the other statutory mental mitigation. But there was testimony that he, had depression. He was good in the military. He has a tendency to exaggerate his position. For example, he said he was going to buy Celine Dion's home. So he has that personality disorder or personality flaw. And it was just an overall non-statutory mental mitigation presentation. If there are any other questions, if not, I will ask the court to affirm the conviction as well as the sentence of death. Thank you.
I feel that I would be remiss if I didn't address the premeditation aggravating circumstance, which my friend discussed. She laid out a number of facts, but again, these facts I would submit are based entirely on speculation and inference. There was
Well,
no...
obviously, if he didn't do it, then you're not going to get it. But on the idea that he knows her, he knows
yes.
she always wears her ring.
Well, no.
Huh?
There's no evidence he
knows that she wore the ring anytime he saw her.
Right.
He knows that she's going to be leaving that day.
No.
No, he doesn't know that. He just guessed that she might be at the home. In other words, I guess...
He doesn't know if she's going to be at home or not.
So is the idea that he might have gone there really just to take the ring and not murdered her?
Well, the state had this contention that he thought that the family was very wealthy, they had a lot of money, so he could have, accepting that he committed the crime, he could have been going there planning to steal money in the house or anything else. The state says he knew the shutters were down the house. There's no evidence that the day that he went to the house to pick up the furniture that he knew that he saw that the shutters were down then. There was no evidence that the shutters were down on the day that he went to pick up the furniture.
His knowledge as to when the victim was leaving. My understanding, she came down, father was placed in this particular sister facility. So there one day.
Right.
And
as a fall.
And from the hospital, he went to hospice. Right.
I believe that's right.
Did he eventually pass away?
Excuse me? Yeah, he died sadly a few days later.
So a few days later. So he knew that he was aware that the father had died in hospice.
No, the father had not died yet. The father was alive at the time of the murder.
At the time of the murder, the father was still alive.
Father was alive.
So he was aware that her sister was flying down that night.
She said that her family was coming down, right.
So there was at least some semblance there of awareness on his part that these folks were not going to be around long. Right?
Well, maybe so, maybe not. I don't want to. This is a death penalty case, but he may have been thinking, well, okay, maybe the father's going to die and they'll all be here for another week. It's speculative. The state relies on this inference that he knew she was leaving that day, which is only that. It's an inference. They had these circumstances which are simply built on inference after inference.
But if we accept these facts pointing to him being there, let me ask you about a related circumstance. Was there a car in the driveway? Was the victim's car in the driveway?
When he gets there, yes.
Okay.
Yeah.
So he would have gone to the door knowing that she was there. So this notion that if we put him there based on all these circumstances, the notion that somehow this is just he was hoping to sneak in and rob the place, That's totally fallacious. Her car's in the driveway.
Well,
And apparently he knocked on the door, or he made some noise that she thought sounded like a knocking on the door.
Mhm.
Isn't that correct?
Right, right. Well, there's a knocking on the
Isn't
door.
the overwhelming inference from that he went there and knocked on the door, knowing that she was there, and knowing what he had to do to accomplish what he wanted to get, what he wanted to get?
Well, the state's inference is that when he left his house, he knew that she was there, which the evidence just doesn't support. When he gets there and he pulls into the driveway, the car is there. Now, yes, he could have backed out and driven away, or he could have knocked on the door because maybe he thought she had seen him. He didn't know whether she would have seen him coming up the street or heard the car pull into the driveway or anything like that. So, I mean, it's just speculative as to what was happening at that point. Maybe he went in thinking to talk to her, and suddenly something happened, you know, which caused him to strike her. I mean, we just don't know.
But even if a court would determine CCP would not be applicable here, we still have a determination of HAC, pecuniary gain or during a robbery or burglary, and very limited mitigation, do we not?
Oh, I don't think that, I think you're looking at mitigation the wrong way. Harmless error analysis has to consider how the jury sees things. And I would submit to you that the jury, looking at this person at this age, without a significant criminal history, they would think that this person's not going to be a future danger. This person is subject to rehabilitation. The way the juries see things is that's very important mitigation. Now, we've been trained in the years since Furman to focus on this mental mitigation, but jurors see things in a completely different light. And I cited in my reply brief the studies about this. If you're doing your harmless error analysis based on how the jury sees things, the jury could see this as being a very mitigated case. The reason we got focused on the mental mitigation was all the time up through Furman, this was the classic kind of mitigation that you had. The guy had been served in the nation's armed services. He had lived this life crime-free except for this check business, which was involved in the dissolution of his business. And he had a good job in the community. That was always considered what mitigation was. Only later on, after Furman, that we start focusing on these people who commit crimes all the time because of mental illnesses. Those people were traditionally considered not mitigated. But I submit to you that from the jury's point of view, this is not a little least mitigated kind of case. Well, I have 50 seconds left. I won't reach any other issues. Thank you very much. We ask that the court reverse the conviction and sentence in this case. Thank you.
We thank you both for your argument. We now go to the fourth and final case on today's docket, Dunbar versus the state of Florida.
May it please the court. Good morning. I'm Dave Morgan. I represent Andre Dunar. Mr. Dunar was convicted of armed robbery with a firearm. He was sentenced on count one. There was a number of cases, counts, but only one that's at issue today, and that was count one, which was armed robbery with a firearm. The judge sentenced him to a sentence of life. There was a minimum mandatory that, per statute, is applicable, but was not imposed. The judge later in the day added it to the sentencing order.
Is there any, this is, and I've been struggling with this, going back to Ashley and the rules, that if the state, if it had not been imposed, the state would have been entitled to appeal the illegal sentence.
I think so.
But, I mean, under the statute,
No,
there's no
under-
question.
I'm sorry, I think under the rule, 9140.
Well,
But unfortunately, I don't have my book with me, and I didn't
well, the
anticipate that
statute
question.
really establishes the right if we buy the fact that it's that the legislature creates the
Yes, I agree.
issue. So-
I
It's not,
am
a
unaware.
it's not a discretionary minimum mandatory. The judge had no discretion. He had to impose the minimum mandatory. Isn't that correct?
I don't dispute that.
So my problem here, and again, I concurred sort of reluctantly in Ashley, but Ashley was a discretionary violent offender, really going back to, and I know that you've got on your side not only the 2nd District, but I see that Charles and Tran from the 3rd and 4th all have said it. But how do you get around the fact that by the state still could have appealed it and with the same result? How is it double? In other words, how's there an I guess the issue is, how is there an expectation of finality, at least during the time that the state has the ability to appeal it? I don't think forever. I don't know that they can use 3.800A, and we've said they can't use 3.800B. I mean, the rule says it. So how can they have an expectation of finality in the 30 days after the sentence is imposed in what is clearly an illegal sentence?
It goes to and I'm sure we'll disagree what the definition is of illegal. This court has said that the contrary written order, contrary to the pronouncement, is the illegal sentence.
No, I understand that, but the definition of an illegal sentence is one that nobody under any definition of sentencing law could ever impose. As Justice Kennedy just said, and it seems like you're not disputing it, that it was ministerial. I mean, he had no choice but to give him first of all, I'm not sure, to give him the 10-year mandatory minimum together with the life sentence, so that for whatever that does to his ultimate sentence, I don't know, but I'm assuming it's important to your client. So I just don't get how there's double jeopardy in this particular case at least for the 30 days where the state could have appealed it if the judge hadn't done what the judge did. Or let me give you another way.
Okay.
If at least you're correct that he should have been there, the defendant should have been there for resentencing.
Yes, absolutely.
Now it goes back to resentencing, and the judge again doesn't impose the 10 years. You would again, I am assuming, agree that the state at that point could appeal the illegal sentence.
I think yes.
So maybe it's so I don't, there may be a procedural glitch, but I think that what we were looking at is whether there is a constitutional glitch, a double jeopardy glitch under the law of both the U.S. Supreme Court as well as this court's law.
Right. Well, I'll make it easy. As far as the U.S. Supreme Court, I waive that argument. As far as the law in this state, the double jeopardy law, it's once the sentence is imposed, the sentencing hearing is concluded, starts serving his sentence, that's when double jeopardy attaches.
But except that you've already agreed that under the statute and the rule, the state can appeal an illegal sentence.
But well, of course, the state never got the opportunity because the judge went.
Okay, so we go and so we take this and say, all right, it goes back for resentencing, and the judge is on resentencing required to impose the 10 years. Would that it wouldn't make your client any better off? I mean, we could say that.
Well, nothing's going to make my client better off. He's got a life sentence. He's going to serve life.
And may I just ask, because correct me, how does, when he has a life sentence, how does the 10-year mandatory fit in? Does that affect gains? I mean,
I don't know. I don't know, but I know it was not pronounced, and I looked at the law.
Ashley, I mean, let's be real about this. Isn't Ashley really based on, and this whole notion of the oral pronouncement being superior, to the written sentence, based on the notion that the sentence that is orally pronounced is in fact a legal sentence. And actually, while he didn't do what the habitual offender, I think it was designation, that's correct, isn't it? Or habitual violent felony.
Yes, it was violent as opposed to...
At that point, that was a discretionary call on the judge's part, correct?
Yes.
So the judge didn't have to do it, correct?
That's correct, Your Honor.
And so the sentence that the judge actually pronounced in court was a legal sentence.
Yes, Your
correct?
Honor. Yes.
So, isn't all of this really based on the notion that the oral pronouncement is in fact a legal sentence?
And due process right to be present when sentence is imposed.
I understand that absolutely correctly. You're absolutely correct. If you're going to impose sentence, a defendant needs to be there.
Yes, no, I'm agreeing with Your Honor.
The notion of the oral pronouncement is that the oral pronouncement is a legal sentence.
That is correct.
So what Ashley is about, if I remember correctly, is, if I'm understanding this, is a judge revisiting a discretionary decision that the judge made.
Yes, Your Honor.
That's not what we have here.
That is not what we have here.
But we do ask a question with regard to many times we speak of, quote, illegal sentences and whether this is, quote, illegal. What role does the appealability of what has occurred played? Because it seems to me that the expectation of finality doesn't turn on just the magic word. It turns on whether the state can seek review of that or the defendant, and for the expectation of finality. Isn't that what it turns on?
Well, Your Honor, I must admit that this, I understand where we're going, and the fact of the matter is that it's going to undermine case law, not only case law, but a number of Florida rules of criminal procedure, that one says, one of them says it is a sentence or other final disposition.
Well, but again, where the discussion comes from is that just because a sentence has been pronounced doesn't mean that that's always going to be in place and that any change in it is going to result in double jeopardy. You agree with that?
I agree with whatever this court says. Seriously and respectfully, I'm not trying to be smart here.
Well, no, nor am I. And we're just trying, it seems to me that it comes down to the issue of whether that sentence is in a category that cannot be changed on appeal. Because if it can be changed on appeal, then that's not, there's no expectation of finality, and it's not a double jeopardy violation if some other sentence results from an appeal.
I understand what you're saying.
It's not every case that the state can take an appeal on, it seems to me, at least right now.
Right.
And so would it not turn on whether the state has the legal authority to seek review of whatever's occurred? Because if not, then you are thrown into whatever you call it, if no one can seek review of it, there is an expectation of privacy, it seems to me, whether you term it mumbo jumbo or term it illegal, whatever the buzzword is. It seems in effect that it has to do with the question of, can somebody seek review of this, and is a defendant have a reasonable, rational expectation that the sentence will not be increased for double sentencing purposes?
I don't, and again, I'm not being wise, but I don't know many reasonable, rational defendants. And their counsel hopefully are, and I have to concede, yes, it's not final until the appellate exposure at least is
so why
final.
wouldn't the better, for this case, just say that, first of all, the judge doesn't, he's pronounced the sentence, he can't just on his own go back and make a change without all the parties being there.
Right.
At that point, if all parties are there and he says, no, I intentionally left off the 10-year mandatory minimum, again, for whatever reason, and the state goes, but judge, you can't do that. And the judge says, I'm doing it. And at that point, the state goes, okay, I am now going to appeal it. I appeal it, and then any appellate court goes, it's mandatory. You didn't have that discretion. So you may be right that we should get there that way, which is that the procedure needs to be the defendant's there, and then the state goes ahead and appeals it, so that we have the process protected.
Right.
But for double jeopardy purposes, we've got to be clear that in this narrow exception, which is where there is no discretion, that it is not an Ashley situation for double jeopardy purposes.
I understand.
Now what if, and I would ask the state this, could the state and the defendant agree to waive a mandatory minimum and ask the judge not to impose it? Does the state have that ability?
I don't know the case name off the top of my head, but I have seen cases that says yes,
so
the state can do that.
So that's why I don't really agree, and I don't know if, I have never seen the state use 3.800A, which means that they could come in any time
Right.
and get this corrected. I think that's to A and B, and B expressly says it's not to benefit, it's only if it benefits the defendant.
Right.
So I don't really see how, so I think they have, my view is they've got that 30 days to decide, is it legal or illegal? If it's illegal, they appeal it. If they don't appeal it, that's the sentence. There's an expectation of finality at the end of 30 days.
Sold.
Well, so you kind of win and lose, I guess.
I mean, quite frankly,
Or lose and lose.
what bothered me most about this was that it happened the way it did, that he wasn't in front of the judge.
I think
there was a problem.
And I think that's we got to make sure, because we've seen these cases, that when a judge goes, uh-oh, because the judge is busy, the judge can't just go, uh-oh, and a state can't call the judge and go, you got to do this. Got to bring the defendant back for resentence. So I think you're on that point, it's well taken, and we ought to make sure that's done correctly. But it's sort of telling, and again, obviously you're here on direct conflict, but that you can't even tell me the effect that this mandatory minimum is going to have on the defendant's life sentence.
It's going to have no practical effect. But quite frankly,
Is it that he doesn't get any gain time?
But a life sentence.
Mandatory minimum portion.
Well,
and then
gain time
so
off
that
of what?
makes-
he's definitely going to do 10 years. That we know. But other than that, I really see no practical impact on his sentence. I just don't. But again, I'm playing to the audience. I'm coming before this court. I'm not just arguing one case. I want everybody to have the opportunity to be before the court when they're sentenced. So that's my case. Thank you very much.
May it please the court, I'm Ann Phillips here on behalf of the state of Florida. It's the state's position that the 5th District Court was correctly determined that double jeopardy was not violated in this instance. The trial court did not have any discretion
But
to
how
not...
about procedure? Let's talk about the procedure. If this had gone on and this judge hadn't done something, and 10 years later or 5 years later, the guy's somehow going to get out. They said, state, you forgot to put the 10 years on there. Can the state use 3.800A?
The state can. There's nothing in the rule that prevents that.
Do we have one case where the state has ever used 3.800A?
Not that I'm aware of. There are cases that say the state appears to be able to do it, but I'm not aware of one where this...
B expressly says they can't.
Correct.
So we have something which says for the shorter run, the state can unless it benefits it, but we've never had a case under A. And it's pretty clear that there's an appeal by the state. They can appeal. So they got 30 days to appeal. And that's it.
Yeah, this case sort of falls in a procedural black hole.
I think that would be, if after the 30 days, the state could go and try to bring motions to a defendant who's not represented, and years later, we would, I don't think the state's even ever, I can't think in my 18 years as a judge that that's ever happened.
Correct. At a minimum, I would say that would be the earliest that he's going to have a legitimate expectation of finality in his sentence. In an illegal sentence, the state would say there is no expectation of finality in that, and that the state, under a 3800A, could correct that at any time prior to his release. You may have
That's a hypothetical. That's
Absolutely.
got nothing to do with this case, does it?
Correct.
So again, let's go back to the question, the state expert. Can the state appeal any adverse sentence?
Not any adverse. We can appeal, the state can appeal in limited circumstances.
Okay, there you go. So is every appeal that can be taken, or every sentence that can be taken, every sentence for which an appeal can be taken, are there other kinds of illegal sentences for which, or contrary to the law, for which an appeal cannot be taken?
If it is illegal, I can't imagine a situation where the state could not appeal.
Okay, all right. So the answer is that any time it's illegal, according to the state, then the sentence itself is subject to appellate relief.
Yes.
Okay.
And as I said,
and I don't think and it sounds like even the defendant doesn't disagree with that.
Correct. And so to include that minimum mandatory, when you're talking about a mandatory non-discretionary item, you're not going to violate double jeopardy principles. And that's really what the state is here on, is that this isn't a double jeopardy issue. I believe Justice Quinn said it, that there may be a constitutional glitch in the way it happens, but it's not going to be double jeopardy that bars the imposition of a minimum mandatory in this case.
Understand this. Did the defense attorney agree that this is an illegal sentence?
Yes.
So the defense attorney agrees that not doing the minimum mandatory constitutes an illegal sentence.
I believe that's correct, yes.
Can the state and the defendant agree to waive a mandatory minimum?
The state is the only one that can waive a minimum mandatory, and that must be done in writing, and it must appear in any individual court case where they do waive it.
So to me, that sort of also suggests, and we're not here, I agree with Justice Kennedy, but I want to make sure the law is not misstated, that the state can actually waive this. It's to the state's benefit, and we're not here on whether they, 30 years later, could try to seek relief. We're here really to say a few things should happen. Something like this occurs again, the state ought to file a motion.
Yes.
Bring it back before the judge. The judge then, with the defendant there, call the judge up and say, hey, this needs to be in there. I don't know if that happened here or how that happened. And then if the judge still doesn't impose it, they then appeal it. Would that be the way we'd want to tell people to what they should follow? Yes.
This is not. It's a procedural issue. It's not a constitutional double jeopardy issue.
At least within the first 30 days.
Correct. And so, as I said, the state could perhaps do a 3800A. It depends on how 3800A is read. It certainly does not preclude the state, and it says the court at any time. So again, do you want to read at any time as the court realized it and did this here and checked it? Do you want to look at it as in Gardner, where the defendant was called back after the lunch break and at that time realized the illegality of its sentence and corrected it at that time, and sort of look at it as a 3800A correction?
But I guess because the state can waive it, you'd certainly want the parties back to see if there was some reason it wasn't discussed. And we hope, that we know these sentencings can be, complicated. But
correct.
As I read back in Ashley, because I had struggled with that case in 2003, we really impose on the state the obligation to be able to advise the trial court on the proper sentence and any errors or omissions.
Absolutely.
Can I follow up here about the issue of the state waiving the minimum mandatory? Did I understand you to say that the state could waive it by an express written waiver on the record?
Correct.
Is the state's waiver limited to those circumstances? Is that your position?
Yes, absolutely. It cannot waive it by failure to make a proclamation or an objection. There's a single solitary way under the statute that the state can waive it, and it must appear in writing in each case in which it would choose to waive it.
But the judge, without that express waiver, has no authority to ignore the mandatory minimum.
Correct. It is mandatory in all circumstances in that instance. And so the state would seek to have this court allow some sort of procedure for cases like this, because sentencing is it happens quickly, and there are lots of things that need to be pronounced, and not everything is going to be caught every single time. It is absolutely imperative that the state and the defendant go in there prepared, but the best intentions, everyone's human. At some point, this can slip through, and there needs to be a method for which the state can seek correction to the sentence to which the defendant is mandatorily, that he should receive that portion of that sentence. So it's not a double jeopardy argument that would preclude this. There might be a procedural glitch, but there needs to be a procedure in which the state can ensure that the legislative mandates are met and a defendant receives the sentence to which he is statutorily required to receive. If there are no further...
And again, as mentioned by Justice Pariente, all this takes is for the prosecutor present when the judge is pronouncing sentence. Pay attention.
Yes.
And you could have raised it at that particular point, Judge, you forgot the mandatory minimum, and we wouldn't be here today.
Exactly. We would ask that you affirm. Thank you.
I have nothing further unless someone has a question of me.
I agree with you that everybody should do whatever we say. It'd be a much happier world.
It would be. Have a good afternoon. Thank you.
We thank you both for your arguments. That's our last case of the day. The court now stands adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
thoughts of a 6-year-old girl in her own fantasy world. See, you really can travel the world right from the comfort of your own movie seat. An insightful documentary begins our journey this week. Sex and Money, a national search for human worth, reveals scary truths happening right here in our own country. Follow a group of student photojournalists as they travel around the world and discover that the exploitation of children has become the fastest form of organized crime. Be sure to stay after the film for a Q&A and a book signing with Wendy Adelson, Program Director for the Human Rights and Immigration Law Project. This film will be shown Monday, November 7th at 7:30 p.m. The Boy Who Lived is back. Join Harry, Ron, and Hermione for the final chapter of J.K. Rowling's epic Harry Potter series. It's the moment wizards around the world have been waiting for, the battle between Harry and the evil Lord Voldemort. Who will win the war between good and evil? Muggles and wizards alike can catch the Harry Potter and the Deathly Hallows Part 2, Tuesday through Thursday, November 8th through 10th at 7:15 and 10:15 p.m. Also on November 10th, the Ask You Student Life Center will have fun Harry Potter trivia and video games, giving you the chance to win cool prizes in the Cyber Cafe. Plus, the Grindhouse will be serving delicious butterbeer. Our final movie is the 1973 Spanish drama film, The Spirit of the Beehive. Anna is a 6-year-old girl living in the 1940s during the end of Francisco Franco's dictatorship. After having watched the American horror film Frankenstein, she becomes fascinated with the film and she drifts into her own fantasy world. Come and travel with Anna when this movie premieres Thursday, November 10th at 8 p.m. So the movies this week at the ASLC will definitely take you on a journey you and your friends are welcome to join. If you want to learn more about movie times and what else is going on at the ASLC, just go to their website, movies.fsu.edu. That's it for this week's University Update Movie Edition. I'm Patty Clemente, and don't forget the popcorn. The ASLC will definitely take you on a journey. Yeah. All right, I hope this goes well.
Here, it's got a couple of out-of-control curly things.
Oh.
Yep, yeah, you just got it.
Oh.
Yeah, there was just one. Here, there. Yay. Groovy. See, I completely like blend into the bag.
Out of control curly things. Are they better?
have to try not to nod my head too much.
Oh. I'll let you know if you're doing it.
Okay. Hi Seminoles, welcome to University Update. I'm your host, Alana Tusher. We have about a month left of classes, so I hope you've had a chance to explore Florida State. Sorry, I didn't see it. If not, what are you waiting for? Listen up and I'll tell you about all the fun activities going on this, okay. No problem. Ow. Alrighty.
Okay, and don't forget the popcorn.
Hi Seminoles, welcome to University Update. I'm your host, Alana Tusher. We have about a month left of classes, so I hope you've had a chance to explore Florida State. If not, what are you waiting for? Listen up and I'll tell you about all the fun activities going on this week of November 7th. Cannon Blue is coming to Club Down Under November 8th. Originally, the indie band Boxer Rebellion was supposed to be there too, but they canceled. Cannon Blue, featuring singer-songwriter Daniel James, is still planning to be there. His most recent album dropped this summer called Rumspringa. Doors open at 8:30 and the show starts at 9:30. And don't forget your FSU card. Good. I think it's because I said something weird.
No.
Oh.
No, you're good. You're fine. It was all One more button on your top. Wherever it may be.
I don't know how.
Oh, there's none. Okay, there's a button, but there's no buttonhole. All right.
It was too low?
Well, your hair is hitting the this thing. All right, and let me get.
Okay, and don't forget the popcorn.
Hi Seminoles, welcome to University Update. I'm your host, Alana Tesher. We have about a month left of classes, so I hope you've had a chance to explore Florida State. If not, what are you waiting for? Listen up and I'll tell you about all the fun activities going on this week of November 7th. Cannon Blue is coming to Club Down Under November 8th. Originally, the indie band Boxer Rebellion was supposed to be there too, but they canceled. Cannon Blue, featuring singer-songwriter Daniel James, is still planning to be there. His most recent album dropped this summer called Rumspringa. Doors open at 8:30 and the show starts at 9:30. And don't forget your FSU card. Good day, mates. All the way from Australia, Architecture in Helsinki makes a stop at Club Down Under on November 9th. This indie pop band has a variety of instruments that they use to get the crowd grooving. From trumpets to tubas to hand claps and drums, this band specializes in surprises. Get there at 8:30 so you can see and hear the band perform at 9:30. Imagine New York City more than 100 years ago. Now imagine how life would be for a woman of color during that time. That's the setting for the School of Theater's play, Intimate Apparel. The story explores the life of a woman named Esther who is a spinster. She makes sexy lingerie for a variety of women, ranging from wives to prostitutes. This play will be held at the Lab Theater on November 9th through the 12th at 8 p.m. Visit theater.fsu.edu for ticket pricing. This Friday is 11/11/11, so you have to make the ultimate wish. Did you wish for no classes? Well, you got it. This Friday is Veterans Day, which is a university holiday, and that means you get to sleep in because all classes are canceled. Also, did you know that every Friday you can practice your bowling skills at the Crenshaw Lanes in the Union? They have Cosmic Bowling until 2 a.m. Grab your friends and start the weekend off right. Well, that's it for this week's University Update. If you have an event that you would like to let us know about, email us at fsuinfo@wfsu.org. Stay tuned in to 4FSU to watch our weekend movies and sports editions of University Update. I'm Alana Tesher, and I'll see you later. Of University Update. I'm Alana Tesher, and I'll see you later. I don't know if I'll probably just keep messing up. I'm like out of it.
Mm-hmm.